before. If you only memo 100, they will take and next day 100 will list. If it won't list, all staff has to be stand in front of it. That was the beauty. Now when these modern judges came,
ಯಾವ ಡೇಟ್ ಕೇಳಿದ್ರು ಆ ಡೇಟ್ಗೆ ಹಾಕಿ.
Agapasan is the first offender and Krishna Kumar is the second offender. One, I think out of trend, I see that.
ಕೊಡಿ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ನಾಳೆಗೆ ಕೊಡ್ತೀವಿ ಸರ್. ನೀವು ಯಾವ ಡೇಟ್ ಕೇಳಿದ್ರೆ ಅದು ಕೊಡ್ತೀವಿ. ಎಲ್ಲಿದೆ ಫೈಲ್ ಎಲ್ಲಿದೆ ಬರ್ದೇ ಇಲ್ವಲ್ಲ ನೀವು? ಪೆಂಡಿಂಗ್ ಬೆಂಚ್ ಬರೀ ನೀವು ಎರಡು ಒಂದೇ ತರ ಇದೆ ಸಿಗ್ನೇಚರ್. ಅವ್ರೊಂದು ಇಟ್ಕೊಂಡ್ಬಂದ್ರೆ ನೀವೊಂದು ಇಟ್ಕೊಂಡು ಒಬ್ಬರೇ ಕೊಡ್ಬೋದಾಗಿತ್ತಲ್ಲ ಅಂತ. ಯಾವ್ದಿದ್ರು ಮೇಡಮ್ ಡೇಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಕೊಡ್ತಾ ಇದೀವಿ. 2ನೇ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತಪ್ಪ. ಎಲ್ಲ ಮೆಮೋಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ, ತಗೊಂಡಿಲ್ಲ. ನೀವು ಯಾವ ಡೇಟ್ ಕೇಳಿದ್ರೆ ಅದೇ ಡೇಟ್ ಕೊಡ್ತೀವಿ. ಫಾಲೋ ಅಪ್ ಮಾಡಿ ಅಷ್ಟೇ. ಎಲ್ಲ ಆಫೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಕಂಪ್ಲೈ ಕುಟ್ನಿ ಆದ್ರೆ ಎಲ್ಲ ಮಾಡಿದೆ. ಇದೇ ಇದೆಯಲ್ಲ ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಎಲ್ಲ ಬಿಡಿ ಪರವಾಗಿದೆ. ಎಲ್ಲಾದ್ರು ನಾನು ಮಾಮೂಲಿ ಲೇಟಾಗಿ ಹೋಗ್ತಿದ್ದೆ ಡೈಲಿ. ಹೆಣ್ಮಕ್ಳು ಕೆಲಸ ಜಾಸ್ತಿ ಇತ್ತು ಮನೇಲಿ. ಫೈಲ್ ಸಿಗದೆ ಇರೋದಕ್ಕೆ ನಾವು ಜವಾಬ್ದಾರಿ ಅಲ್ಲ. ರಿಜಿಸ್ಟ್ರಾರ್ ಇದ್ದಾರೆ, ಹೈಯರ್ ಅಥಾರಿಟಿ ಇದ್ದಾರೆ, ಅಲ್ಲೋಗಿ ಇದು ಮಾಡಿ. ನೀವು ಹೈಯರ್ ಆಫೀಸ್ ಹತ್ರ ಹೋಗಿ ಯಾರು ಎಲ್ಲ ಇರ್ತಾರೆ. ನಾನ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಏನು ಮಾಡಲ್ಲ. ನಮ್ಗೆ ಫೈಲ್ ಸಿಕ್ಕಿದ್ರೆ ಅಲ್ಲಿ ಯಾರಿಗೆ ಇದು ಮಾಡಿ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ಬಂದಿಲ್ಲ ಅಂತ. ನಾವಿಲ್ಲಿ ಫೈಲ್ ಕೊಡಕ್ಕೆ ಟೈಮ್ ಇರಲ್ಲ ಸರ್. ನಾವ್ ಹೆಂಗ್ ಫಾಲೋ ಅಪ್ ಮಾಡೋಣ? ಹೋಗಿ ನೀವು ಯಾರ ಹತ್ರ ಹೋಗಿ ಅಲ್ಲಿ ಹೋಗಿ ಹಾಕಿದ್ರೆ ಬನ್ನಿ. ಆಮೇಲೆ ಫಸ್ಟ್ ಯಾರ ಹತ್ರ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತಾರೆ. ಕೊಡಿ ಎಲ್ಲ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಪೆಂಡಿಂಗು ತಗೋತೀವಿ, ಸ್ಕೂಟ್ನಿನೂ ತಗೋತೀವಿ. ನೀವು ಯಾವ ಡೇಟ್ ಕೇಳಿದ್ರೆ ಅದಕ್ಕೆ ಕೊಡ್ತೀವಿ. ವಿಡ್ರಾವಲ್ಲ ಆಯ್ತು, ಬರುತ್ತೆ. ಆಫೀಸಲ್ಲಿ ಒಂದು ಮೆಮೊ ಹಾಕಿ, ವಿಡ್ರಾವಲ್ ಮೆಮೊನ. ಇಲ್ಲ ಓಪನ್ ಕೋರ್ಟಲ್ಲೇ ಕೊಡ್ತೀರಾ? ಕೊಡಿ ಬರುತ್ತೆ. ಯಾವ ಡೇಟ್ ಕೇಳಿದ್ದೀರಿ? 19th ಮೇಡಮ್. ಯಾವ ಡೇಟ್ ಕೇಳಿದಿರ ಅದಕ್ಕೆ ಹಾಕಿ. ಫಸ್ಟ್ ಲಿಸ್ಟೇ ಫಸ್ಟ್. ಹೌದೌದು. ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇವತ್ತೊಂದಿದೆ.
ನನ್ನ ಜಡ್ಜಸ್ ಪ್ರಾಕ್ಟೀಸ್ ಇದೆ.
ಹೋಗಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು. ನೀವು ಹೋಗಿದ್ರೆ ಆ ಕಡೆ ಕುಡಿ ಅಲ್ಲಿ ಕಾಲ ನೋಡಿದ್ನು. ಫೈಲಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿರೋ ಮ್ಯಾಟರ್ ಬರೋದಿಲ್ಲ.
4 ಗಂಟೆಗೆ ಜಡ್ಜಸ್ ಅದೆಲ್ಲ ಈಗ ನಮ್ದು ಈಗಲೇ
ಮೇಡಮ್ ನಾಳೆ
ಗೊತ್ತಾಯ್ತಾ ಸರ್? My lord, kind you, my lord. Extreme urgency is involved with it. Otherwise, not troubling your lord. Yes, how or injection. In equipment, my lord, the Narayan Hotel, all the fast no order as per filed. It is my lord 5/6/2026. Immediately after the reopen of the court, we have filed for suit for permanent injection.
How many days now?
KVT is there because of KVT has asked time. Court has said by looking the defendant's name.
Not take it up at 2:30, no urgency.
My lord,
File the petition, no.
may I make one more submission, my lord?
Yes.
Only for assistance, my lord. I have, my lord, deputed and 95 staffs. Every day, my lord, 8,100 plates I have to provide the food
So
to
you
the.
waited for 20 days. Wait for some.
My lord, next date of hearing before the learned trial court is, my lord, that is on 29th of this month. If it is, my lord, it is otherwise, my lord, it is going to be infractious. My only submission, if I don't have, my lord, merits, your lordship, it is a preliminary here. No.
File your petition, and once it is numbered, it will come. I will not take up out of the turn.
No. I'm never troubled, my lordship, my lord, for the 230. Where there is an extreme urgency, my lord, when Article 18, 19(1)(g) of the Constitution, my lord, it violated. On such circumstance, I came, my lord.
Tomorrow will come. Yes.
Yes, ma'am, please.
Your lordship,
Don't take the memo. Once it is numbered, it will come. Yes.
your
Numbered,
lordship,
my lord, it is already numbered.
Come. All fresh matters are coming.
My lord, my
Started
humble
at
submission, my
2:30, your
lord.
lordship.
Again, my
Then-
lord,
That's the reason.
tomorrow is the case for evidence in the trial court, and today it is for impleadings, your lordship. That is the reason.
When was that writ petition filed?
Yesterday, your lordship.
Yes, tomorrow.
Your lordship today, because tomorrow is the case in the trial.
I can hear it tomorrow, no problem. Yes.
Yeah, I'm requesting for hearing tomorrow for vacation of stay. There has been more than 52 lakhs rents due from the petitioner.
Not urgency, there are so many matters.
Like near more than
No.
each and every
Yes.
month.
Call the list.
my lord, humble submission, my lord.
My lord.
Without memo, my lord,
Come,
if I
it will
can't.
come. It
My-
will come. If
My
it
lord.
is not coming, tell the court officer. I will not give you a memo. Yes.
Shall I provide, my lord, number, my lord, case number?
If it is not coming, if I come to know that the office objections are not complied with, then I'll ask the matter to be listed after 1 month.
If it is in board branch, my lord, waiting for the, my lord, listing.
You
My
please
lord.
find out, please wait. You please find out from the registry what is the SOP.
My lord,
And how the matters
every day we
coming.
are filing more than 5 cases in the High Court, my lord, from 2004. We are filing.
For
It is,
2004, what is, please understand.
my
What
lord,
is the-
one
what is the
person
proce-
deploying
What is
behind
the
the file.
procedure adopted by this court is all matters are coming up in the list. You please find out from the registry, what is the procedure, you will understand.
My lord, my only urgency is there. That is what I am troubling the
It will
court.
come
Otherwise, my
tomorrow.
lord, please,
It
my
will
lord.
come tomorrow, provided it is numbered. It is office objections or
Oh,
compliant.
everything
Otherwise
is,
it will
sir,
not-
date has given, that is what not it is listing, my lord. Date has given by this honorable court,
It is already listed.
not listed when office objection was there, that is listed. Immediately, my lord, date has given. When, my lord,
You have to tell the court.
immediately rush it.
You are giving an impression as if it is pending for consideration in the registry for.
My lord, very next day morning, I have removed everything through my clerk.
What is the date given?
That is, my lord, 3/7.
Hmm?
3/7.
If office objections are compliant.
Everything,
list
sir.
the-
That is, my lord, my
Write on that. If office objections are compliant, list the matter.
oblige me.
My
Deeply
lord,
oblige, my lord.
trial
Great.
court has issued the delivery warrant, my lord. My lord,
When was it issued?
last week, my lord.
Yes, it will come, you file it will come, memo is not.
In that
required.
case, we are not party, mayor. We are objector.
Whatever it is, we will deal with it, file it, don't give the memo. Yes,
My lords, the parted matter, I had made deposit yesterday. It was directed to be listed today. Date was
It is
also
not
given.
listed.
Unfortunately, it's not.
just take it up at 2:30
Tomorrow, ma'am.
My
Tomorrow.
lords,
tomorrow.
my
Yes.
lady,
My lords, the amendment application.
Please don't make the court to again repeat the same things for fresh matters. I will not give any memo. It will be listed. That is a specific instruction from the court. Yes.
Trying to put up
my
the
lady, may I
conception.
make a mention for an urgent matter?
Please, my lords. Amendment application came to be allowed by the Honorable Trial Court. They've changed the nature of the property, my lords.
Forget about it. What is the writ petition?
Writ petition, my lords.
Is it filed?
It was filed yesterday, my lords.
If it is filed yesterday, if you comply with office.
Yes,
of-
everything is compliant.
It will come.
May I
It will
seek
come.
for 2:30, my lords?
No, no, no. Yes.
Or at least for tomorrow, my lords?
It will come. Yes.
Writ petition was filed in
Please, much
April,
obliged.
and the stay was granted, whereas more than 70 lakhs for rent was pending. And like I already filed the IA for vacation of stay. In previous date,
To 500, 6 above, around 2-3,000 matters are pending for vacate petition. Yours is not out of the turn, it need not be taken. So please don't make mentions. The matters will come as how they are coming, and I will not take up any matter out of turn because all are vacate petitions.
the 3 months.
Why your matter is so
The
urgent
3
and
months,
others are
the
not?
3 months stay period will be, whereas the date has been given on later date. It's 3 months stay period will be vacated. Already the delivery warrant is due for delivery. It's my humble request because
No,
every month the rent is getting more than 70 lakhs.
Yes, call the list.
Page-wise adjournments.
Malady,
List number 1.
My lord,
Page
I
number
wanted to
3.
make a mention for an urgent matter. This is a virus challenge to regulations from the CERC, the Central Electricity Regulatory Commission, and interim orders already been granted by this honorable court. I'm only requesting it be taken up tomorrow because I'm an under construction wind project, my lord, and I'm facing unviability. My project cannot continue without that interim relief, my lord. That's the only reason I'm asking it, for it to be
When
listed
you
sometime.
file the writ petition,
I filed it on 15th, my lord. I have already cured the defect. I just need a listing
it will
direction.
come, it will come. Otherwise, why it is not coming, find out from the registry and tell the
The-
court officer. Yes.
My lord, the
Call the
registry
list.
is saying they need a direction from your lord, my lady. That's the only difficulty, my lord.
Call the registrar.
Page-wise
judicial.
adjournments, if any.
Very good.
Court
Page
officer, call the registrar judicial. Yes, call the number.
Page number 3, serial number 9 to 11. Page number 4, 12 to 14. Page number 5, 15 to 19.
My lord,
Page number 6,
my lord,
20
serial
to
number
28.
19. This matter is connected with the main matter in the month of July. So today is need urgent. This matter is serial number 19. It's connected with the main matter. Main matter will be posted on July month. So kindly check this.
List along with that matter in the month of July. Yes,
Page number 6, 20 to 28. Page number 7, 29 to 36. Page number 8, 37 to 43. Page number 9,
Serial number 42, my lords. There's a connected matter which was heard yesterday. It was posted on Friday. So I'll
give the
post.
number. List
I'll-
along
I'll-
with so and so on Friday.
number
Yes.
page number 9, 44 to 54. Page number 10, 55 to 59. List number 2, page number 1, 1 to 3. Page number 2, 4 to 6.
Serial number 5, my lords. We had a notice had been issued, but we have to give new address, my lords, because it's not coming. So a week's time may be granted, my lords. We'll furnish new address. And
I have 1/25 for bringing the LRs of deceased R3. That is what is pending. You have an interim order in this?
no, my lords.
You don't have an interim
No,
order?
ma'am.
Yes. This is matter in the month of September. Yes, next.
Page number 3, 7 to 11. Page number 4, 12 to 15. Page number 5, 16 to 21. Page number 6, 22 to 27.
Lordship, serial number 22, your lordships. And for the petitioner, it is for awaiting report, your lordships. In the next week, it may be taken up, your lordships.
This is
Interim
matter.
order may be extended.
So this will be request to respond in R1 to R5. Interim order earlier granted is extended. Yes.
Much obliged.
Page number 7. Page number 8, 28 and 29. Page number 9, 30 to 34.
Serial number 34, my lord. Senior's father undergone open heart surgery. Kindly request for 2 weeks of accommodation.
My lord, appear for the respondent number 1 and 2 in serial number 34, my lord. We have previously moved the matter 5 times. They've been taking some of the, they've been taking adjournment on some of the other 2 times. A small date may be fixed in testing
This
medical.
is matter
34.
On 24th of June, at the request of non counsel, the petitioner, no further time will be granted.
Please.
My lord,
The interim order earlier granted is.
a kind request to list it, that is, to the matter to come in list 1, my lord.
Kumar sir, mute ಮಾಡ್ಕೊಳ್ಳಿ.
Yes.
please.
Page number 10, 35 to 39.
My lord, serial number 39, my lords, I appear for the respondent. My lords, the suit is already disposed, appeal is also disposed. This writ petition does not survive, my lords. I've informed my learned friend also. Your lordships may dispose it as having become infructuous.
This is questioning an IA.
Please, my lords, IA in the suit.
Counsel appearing for the respondent submits that. The writ petition is filed, questioning an order passed in the IA, and the main suit itself is disposed of, and against that, an appeal is filed.
Appeal is also disposed.
Appeal is also disposed of, considering the recording the submission of the grounds for the respondent. The writ petition is dismissed as infructuous.
I'm grateful.
Page number 11, 40 to 48.
Serial number 40.
Serial number 48, my lord. In this case, this notice has been served on the respondent, who has not appeared because of some inconvenience. I require for 1 week time.
You appear for respondent.
I am appear for petitioner.
Have you informed the other side?
No, it is served. Nobody has represented.
Does this matter in the month of September?
Free matter.
This interim order only granted is extended.
Lordship, serial number 40 for the petitioner.
Serial number?
40. We have filed an NOC of Kalat last week, and we need 2 weeks of time.
Last time also you have sought for time.
Yeah, senior.
No further adjournments will be granted. Have you informed? It's a fresh matter.
Yeah, it's a fresh matter.
This
Senior is out
matter
of station.
in the month of September. In spite of repeated adjournments, today again adjournment is sought. There appears to be no urgency for this matter. List in the month of September. Yes.
Page number 12.
43, my lords.
40.
43, my lord. It's a personal inconvenience. Matter may be
Have you informed the other side?
Yes, my lords. Even they were.
Yes, this also at the request of grounds for the petitioner. List in the month of September. Yes.
Page number 12, 49 to 51. Page number 13, 52 to 56.
Serial number 54, your lordship. Appearing for the respondent, prays time to file an objection, your lordship, for the main petition.
At the request of grounds for the respondent, list this matter in the month of September. Look at it if interim order is there, extend.
54.
My lord, serial number 55 and 56, my lords, we have for the petitioners. Kindly have it after 2 weeks, my lords.
This matter also in the month.
Interim order may be extended.
In the month of September, interim order only granted is extended. Yes.
55 and 56.
Page number 14, 57 to 63.
Serial number 58, my lord. I appear for petition. I pray for accommodation, short accommodation, my lord.
Have you informed the other side?
No, my lord. Some personal inconvenience, my lord. I am not able to come to court, my lord.
Then please wait for your turn. Yes, next.
Page number 15, serial number 64.
Please call the rest.
List number 1, pronouncement of order. Serial number 1, Surupes.
Dismissed.
Serial number 2, R. Shashidhara.
The petitioner in this case, my lord.
For respondent.
Yes.
My lord, wife of the petitioner is informed that, my lord, petitioner is met with accident. He is a deathbed, my lord.
Who?
Petitioner.
The petitioner is a school teacher. That he is required to pay. Kindly see, he has not complied the court order, madam. This honorable court was pleased to granted interim plus.
Have you heard what he is saying?
Sorry.
Petitioner is deathbed, my lord.
He submitted that the petitioner is met with an accident.
May request.
He is on a critical condition. Is this matter on 22nd of July?
May request, madam. Interim order, madam, terms of interim order has not complied, madam. Therefore, kindly clarify, madam, there is no interim order. Trial court so that, madam. Kindly.
Okay. At least to fulfill all these interim orders, he should be alive.
Is a to school teacher, madam. It is same submission was made in last question.
What submission?
Kindly see, madam, order sheet, madam.
Look at it.
Kindly see the order sheet, madam. In the year 2022, my lord, he entered into compromise and agreed to pay 24 lakhs, my lord. Till today, my lord,
Recorded. Please tell the court.
My lord, on 15/9/2025, this honorable court was pleased to grant interim order. Thereafter, my lord, 8/10/2025, my time was granted. Thereafter, last date of hearing without deposit, my lord, in my absence, my interim order got extended. Kindly see, my lord, last, though it is not recorded, my lord.
Interim order all granted is extended, yes.
My interim order, my lord, without deposit, interim order.
Serial number 3.
Additional order, why it was not complied with?
Madam, is
So just don't extend interim order, just extend the matter to July.
please.
Kindly clarify, my lord, there is no interim order so that my trial court.
I think court understands the black and white, what is there. When the matter is posted and interim order is not extended, why should it be clarified?
But the trial court, my insisting, my lord,
Not understanding, that is not the problem of the court. Yes.
and my lord, kindly allow the application to my lord, withdraw the amount, my lord. The 22,50,000 is deposited by the.
Deposited.
Please, my
2
lord.
lakhs 50,000 deposited, madam. I have no
Number
objection
1 of
to.
26 is filed seeking withdrawal of the amount. As per the interim order, the said amount is deposited. The respondent is at liberty to withdraw the said. Yes.
Oh, bless.
Number 3. Ganapati Bhatt.
For the petitioners, my lord, I seek short passover. Senior counsel is on his legs before another court.
Pass on, Manoj. We are ready in the month. Either this senior counsel or that senior counsel, every day this goes on and on. I think you should put an end to this. From here onwards, I will not pass over the matters like this. If senior counsel doesn't come, whoever is on record, argue, or else I'll give a long date.
Serial number 4. Pradeep ji, 14%.
I have only 6 submissions. After that, I will leave to the honorable court, my lord.
Yes. But that, whatever I said, that 50,000 will remain to be the same. Yes.
My lord, may I submit, man? When any allegation is made.
No, first of all, you have to submit to the
about
court.
maintainability only, I'm about maintainability, I'm.
No, I'm saying on a suit which is decreed or dismissed. The suit is, you're the plaintiff in the suit.
Yes, yes.
Your suit is dismissed. Against that, you will file an RA.
Yes,
RA will be dismissed for default. Now,
Yes, ma'am.
because there is a fraud, you will file a writ petition under 227
Yes, ma'am.
and file and question the suit proceedings. You show me a strike judgment on that. No other submissions I want to hear. You submit a judgment on this regard that after dismissal of the suit, after suffering an order in a RA,
Yes, ma'am.
on the ground of fraud, you will come before the court under 227.
Yes, ma'am. I
What
have
is the
the
judgment?
I have the submissions.
Yes. Take that. Yes.
So in that, my lord, kindly come to the page number 28.
Which court is this?
This is of the Ramchandra Singh versus Savitri Devi and others. That's Honorable Supreme Court has held that. Quoted.
Rambahan Singh is a Patna High Court.
That is Patna. It has been quoted in SP Changaval Raya Nair or something.
Huh?
So here, my lord,
Which
it has
judgment?
the judgment page number.
Page number, which page?
Page 28, my lord. Come to the page 28 and para 28, my lord. 28 and 35, both paras applies to this one.
You have to come to where the judgment starts, page number.
The main page number is 28 and 30, my lord.
20?
28.
Judgment starts at page number 23.
Yes, my lord.
That is what
Judgment
you are supposed
starts
to
at-
refer.
Kindly come to page 28, my lord. 28.
Please read the facts first.
Yes, in para number, that is in SP Changal Varaya Naidu versus Jagannath, the court held that the principles of finality of litigation.
To paragraph number 3 and read the facts of the case. You can't read the findings in isolation.
No, yes, my lord. The effect of fraud on court is a primal question.
Respondent number 2 here in Arun Prakash Pandey, that you have to read.
Before that,
23.
page number, para number 2 is also with regard to the fraud of the court.
Yes.
Effect of fraud on court is a primal question involved in these appeals, which arise out of the judgments and order dated 10/12/1998, passed in CR so-and-so, and dated 10/5/1999, passed in civil review. So by the High Court of Judicature, Patna. So
What are the facts? You read the facts.
Yes, my lord. Respond number 2, herein Arun Prakash Pandey, herein after called as the mortgager, had taken a loan from State Bank of India, wherefore lands were mortgaged in the favor of the bank. He became a defaulter in the matter of the repayment of loan. The bank filed a suit claiming a sum of rupees so-and-so, at measuring as 95 point so-and-so acres. In the said suit, the sisters of the mortgager were claiming 6 annas shares in the suit's properties, purporting to be relying on or on the basis of the preliminary decree passed in the partition suit. So dated so on, filed by the respondent number 1. In relation to the said mortgage land, a preliminary decree in favor of the bank for the aforementioned amount with pendency light and future interest 6% at rupees 6% was passed. A preliminary decree of sale of rupees 10 anna shares of the mortgager was also passed by the learned 6th additional sub-judge on or about 22/6/1981, whereafter a final decree for the sale of the mortgage property was passed on for 1982 in suit number so on so on. The first appeal was preferred there against by the respondents herein and by an order dated 1998. A division bench directed that the decretal amount be paid in 2 installments. Allegedly, the said direction had not been complied in letter and spirit. However, an execution application filed by the bank, 30 acres also, out of total 57 acres of land was put on auction sale or about 7/6/1988, wherein the petitioner became the highest bidder upon offering sum of rupees so-and-so. Therefore, so the said auction sale had been confirmed by the executing court, pursuant whereto the appellant deposited the amount. The brother of the mortgager thereafter filed an objection in the said execution case purported to be in the terms of section 47 of the CPC for setting aside the auction sale, which was marked in miscellaneous civil so-and-so. The said application was dismissed by the judgment dated so-and-so 1988 inter alia on the ground that keeping the extent of land donated by the parties from their father being 95 acres, 60 acres of the land belonged to the mortgager, out of which only 30 acres had been auctioned. So the appellant here in the terms of the order passed are about 1990 took delivery of possession of the auctioned land. Questioning the judgment and order dated 1988, the respondent filed a review petition application before the High Court in year 1980 marked as a revision petition. The auction sale was set aside by reasons of the judgment dated so-and-so by the High Court, inter alia directing that the following remedy to be taken recourse to by the appellant. So there are 2 points: to seek a partition by filing a separate suit for causing out a separate area from the share of Arun Prakash Pandey, or to file an application in the order aforesaid partition suit for including the area purchased by him in the Takar of Arun Prakash Pandey. So hence the appellant filed a special leave petition there against which was marked as SLP number so and so before this court, which was disposed of by an order dated stating learned counsel for petitioner withdraws this petition to cash upon the order impugned against. Special leave petition is disposed as.
Yes, I've seen this. I've seen the judgment.
So in that, my lord, kindly come to the para 28, my lord. So the High Court has, yes, my lord. And also in para 35 also, once it is said that judgment and decree was being obtained by practicing fraud and court, it is tried that the principles of res judicata does not apply, my lord.
Yes.
So as per the contention of the respondent, they are taking defense that the trial court proceeding is over, RA is dismissed, RSA is dismissed, but so it attracts res judicata, whereas if this court holds that it doesn't, if there is any practice of
It is not res judicata. This is not maintainable for the reason
yes,
that is not, when there are hierarchy of courts.
Yes,
and the appeal that is provided under the CPC. That is how you have to proceed.
Yes, madam. And one more thing, it's important submission, my lord. So yesterday only I have given the memo of citations. In that, when any allegations of fraud made before the appellate court.
Questions of fraud will be decided by the court.
Yes, I'm
which
talking
is
about,
having jurisdiction.
Yes,
not by every court.
The Honorable Supreme
Why
Court.
don't you go to Supreme Court again? Straight away from from that order to the no. You can ask the Supreme Court also to set aside this judgment and decree.
No, when there is an allegation of fraud, the Supreme Court first took the matter on allegations of fraud, then maintainability. That I am submitting, my lord. So here, what this happened. The allegation, when there is an allegation of fraud, the appellate court has first
This is not an
examined.
appellate court.
No, my lord. This court is bound from the.
This is not an appellate court. Your appellate court is the one where RA was pending and which was dismissed for default.
No, I'm
I'm
not.
telling you, you're just wasting the court's time.
No, my lord.
And it's an abuse
And
of
also-
process.
No, my lord. Exactly. Just I give 4 submissions.
Why have you not contested the RA?
R8 is dismissed due to default. It has not attained finality. And also this
When was it dismissed for default?
2001, my lord.
According to you, 2001 dismissed for default.
Yes,
In
ma'am.
2027, it has not attained penalty.
No, still it has not attained. We have not challenged that.
What do you
also, my
mean
lord.
by, what does that submission mean? That it has not attained penalty? Means what? That you cannot, now today you can file a petition to set aside that ex parte order and that default order, and you can contest the matter.
No, but not like that.
And then,
So when the RS has dismissed due to default, I have not, it was not
so the
decided on
judgment
merits.
and
ma'am.
decree,
It was not decided on
decree
merits.
has attained penalty.
No, it was not decided on merits. So it was not heard and adjudicated, my lord.
Yes.
That's what. And
Hmm?
and also the ends of justice, my lord. Ends of.
No, everybody comes and makes a mention that even after complaints of the office objections, it is stated that no, they say that unless and until there is a memo from the court, they are not listing it. Why is it so? And I am not restricting the list. I am asking you to list every matter, and every day all this memos business will not go on like this. And please instruct them, wherever the office objections are complete, they should come before the court immediately, next day. Oh, I'm not restricting the number of cases. And every day, like so many advocates coming and mentioning, and everybody says it is numbered long back. No, as per the procedure now, once it is numbered, you can't keep it. And in my court, let the matter come. If it is numbered today, let it come tomorrow itself. And please instruct them. Yes. Yes.
And my lord. Even the res judicata does not apply. It says in the Sharda Singh versus Asha Agarwal, my lord. That also have produced the here. Just may I read that one, my lord. Section 11 postulates that matter must have been heard and finally decided, my lord. Dismissal of the suit for default not being a decision on merits cannot ordinarily be regarded as a final adjudication so as to attract the strict applications of the section 11, my lord. So here also, even the RSA has been filed from our side. I have not challenged that one. It is not attained finality. When there is a fraud, allegations of fraud, so it does not attract at all, my lord. That is the one. And first, when there is allegations of fraud, first maintainability has to be taken, examined first, my lord. Later on, sorry, maintainability. First, allegations of fraud has to be examined first, and then have to. That's what the Honorable Supreme Court has done, my lord. So I request this Honorable Court to kindly pass the order, my lord.
Yes, dismiss with cost of rupees 1 lakh. 1 lakh to be paid to the legal service authority. Yes, next.
Along with that, I'm filing again. Written argument, kindly
Yes, next.
pass orders on merits, my lord. Copy,
Number
sir.
5.
Yes,
Copy,
next.
sir.
Rajaditya Sadashivan.
Regarding maintainability of the petition, it is 7 rule.
What is the impugned order?
7 rule 10 application of mine was rejected. I am for the defendant. Suit is for recovery of money, damages for defamation. The challenge to the jurisdiction of the court was by 7 rule 10 to return the plaint. That has been rejected, against which a writ petition has been filed. The office has raised an objection saying that CRP would be maintainable. My lord, CRP would be maintainable only if the application was allowed, it would amount to a disposal of the suit. 7 rule 10, even if it is allowed in my favor, it does not amount to a disposal of the suit. It is only return of the plaint to be presented before another court. In fact, 7 rule 10A further goes to the extent of the court itself sending the plaint to the court of actual jurisdiction. Therefore, there is no end to the list. It is only a change of the court. So even if the 7 rule 10 was to be allowed, it would not amount to dismissal or disposal of the suit. So therefore, a CRP would not be maintainable. CRP under section 115 is maintainable only if had the application been allowed, it would amount to a disposal of the suit. So therefore, a CRP would not be maintainable. Appeal also is not maintainable. Only if 7 rule 10 is allowed, then an appeal would be maintainable under order 43. So therefore, neither an appeal is there nor is a CRP available. Therefore, my only remedy is a writ petition.
Why CRP is not?
My lord, CRP, kindly see 115, my lord. In section 115 of CPC.
No, that will be it will go to the other court.
it will continue in the other court, but it does not amount to a disposal of the list.
Yes. Yes, argue the matter.
Let's, I have a couple of objections there. Let's, I would suggest that this matter revision is maintainable, Malats, because the order which is passed, if it is passed in the favor of the petitioner, Malats, it results in the termination of the proceedings, Malats, in the Bangalore courts. So therefore, Malats, the revision petition which is maintainable, and therefore writ petition is not maintainable, Malats. I have two
Anyhow,
judgments.
filing a CRP or a writ petition, you're still before this court.
Yes, madam.
Why there is a big fuss on that?
Since we are already before your lordship, we might as well argue on merits, my lord.
Pass on a couple of judgments, Malats.
Let's not consider all that and waste the time. Please convert it into a CRP, the petition.
My lord, the CRP would not be strictly maintainable. I kindly see the provision of law.
Saying do it, the petition.
No, my lord, subsequently I'll be hit by whether the CRP is maintainable or not.
Is permitted
Your
to
lordship would
convert
kindly
this
see the provision of law.
We'll see if you want, this is marked in the month of July. Yes, next.
Number 6.
This is marked in the month of July. No orders on that. Yes.
Ray Prakash.
Lordship, I appear for the petition.
Yes. What is this objection?
The impugned order is on the miscellaneous appeal, which was allowed. Miscellaneous appeal, which was allowed. Injunction order was passed for the earlier. Then I filed in vacating stay, and the plaintiff there, he went for 2 MAs. 1 MA for the challenging the legality of not allowing the 39 rule 182 injunction, and 1 more for the vacating stay, which I got for 2 MAs were filed. That's the this
What is that? 2 MAs or 5?
two MAs were filed. So I mean both the MAs, the injunction order was vacated. I have come on the miscellaneous appeal order in this writ. There is a maintainability.
One against both or one?
Both. One is in the for the register.
Two petitions.
Two I have filed separate. One has come before the court. One more is before the register for the non-compliance.
Then why it says the maintainability?
That's what. That's the question here. There are 2 separate writ which I have filed. One is before the register today itself for non-compliance.
Let writ proceeding folks.
That's
Why is 7 applicable to this?
7 doesn't come to this.
Official clarify regard to what is the issue with regard to the maintainability. This is matter tomorrow. Yes.
7.
For petitioner lordship, filing memo for withdrawal and liberty may be granted to file fresh CRP lordship.
Memo is for second to withdraw the writ petition.
The office may be directed to
Withdraw the writ
give back the certified copy
convert
lordship.
the same into a CRP. Accordingly, petition is accordingly petition is permitted to convert the same into a CRP. For all statistical purposes, the writ petition is disposed of. The registry is there to return all the documents to the petitioner. That when I say file, within 1 week from today, the CRP shall be filed. Yes.
Till number 8. Rohan Veeranna, Tigadi.
My lords, an objection has been raised regarding the maintainability of this petition, my lords, for which I'll produce a citation.
Take that section 299. Succession.
My lords,
Yes.
just for some context, the petitioners and the respondents are the children of A.S. Nagappa, who is passed away. And
This is impugned order, let's see.
impugned order is the order granting letters of administration to the respondents itself based on a will, alleged will that has been given by the father of the respondents and the petitioners, my lord.
Succession Act, you will have separate vote. Hindu Succession Act. Yes.
My lords, in this citation that I have produced, serial number 2, my lords, sorry, paragraph number 2, two questions emerge for decision on this appeal. First, whether the High Court was justified in declining interference on the ground of availability of an alternative remedy of appeal to the appellant under so-and-so of the VAT Act. My lords, if I may take you to the answer to this question is been answered in paragraph 6 of the same judgment, wherein at the end of the last century, this court in paragraph 15 of so and so carved out the exceptions on the existence whereof a writ court would be justified in entertaining a writ petition despite the party approaching it not having availed the alternative remedy provided by the statute. The conditions are so.
Talking about something under 226. You have not filed it under 226.
My lords, it's been filed under 227, my lords. Supervisory jurisdiction. My lords.
Alternative remedy, that is in terms of a 226 and that will not apply to this.
My lords, but here the considerable, like a statutory safeguard that has been provided to the class 1 heirs have been violated, my lords.
You have to, as per the procedure, you have to file under 299 of the Succession Act.
But my lords, but we have not been afforded an opportunity.
That you will agitate before the office objection with regard to the maintainability is sustained, and the petition relies on a judgment in Godrej Sara Ali Limited versus Excise and Taxation Officer, Conversing Authority, reported in 2023 109 GSTR 402. It has no application to the
My
facts
lords,
of
there's
this case.
another judgment of the High Court, my lords, here, according to bench. This is also a writ filed, and the order has been challenged, wherein notice has been issued, my lords. My lords, in the last paragraph, the court.
Yes.
My lords, we have not been afforded an opportunity to contest the will, or as we have not been included into the proceedings in the trial.
Where the court decided about the maintainability in this?
My lords, not regarding the maintainability, but.
Yes, next.
My lords, liberty may be granted to approach the trial court, my lords, for revocation.
Yes, office objection is fell, and the petition is at liberty to avail the appropriate remedy. Yes.
Grateful, my lords.
Number 9, Lingaraju.
Appear for respondent number 1 to 3, my lords.
Okay,
in behalf of respondent number 4,
the first list. No, why should they come in the first list? Oh, yes.
Let. For commencing the argument, my lord, while granting the interim order, my lord, kindly see the order sheet. Both the parties have present. They filed the caveat.
You know, we have to dispose this matter, isn't it? Because both the parties are present, it will not keep it pending forever here.
Yes, madam, it's not that, just I came to
No,
know.
please argue the matter. What is the IA?
Madam, is the plaintiff petition, my lord.
Yes. What is the suit for?
Plaintiff filed suit for, my lord, specific performance, my lord. The defendant number 1 and 3 are the owners, my lord. Owners of the land measuring 28.0 gunta, my lord.
Yes.
My lord, land bearing survey number,
All those details are not necessary. What I want to know is, suit is for specific performance.
my lord,
What is the IA for?
there was agreement, my lord, there was sale agreement, my lord, dated 27/6/2018 between, my lord, plaintiff and the defendant number 1 and 3. My lord, sale consideration is of rupees 28 lakh.
I'm
My
not,
lord,
I'm not hearing a first appeal.
my
I
lord,
want the details.
facts
Where
is
the-
important, that's why.
I will ask, you can argue.
My lord,
The facts which the court wants to know.
my lord, along with plaint, my lord, IA number 1 had been filed, my lord, seeking, my lord, injunction against the defendant number 4,
What is
not to,
injunction?
not to alienate the suit schedule property during the pendency of the
Yes.
suit. My lord, sale agreement has been executed, substantial payment has been made without executing the sale deed in favor of plaintiff, my lord. The defendant number 1 and 3 had executed the sale in favor of defendant number 4. My lord, the trial court came to a conclusion that the defendant number 4 is the bona fide purchaser. My lord, without trial, my lord, how can court come?
Let us see that order. Please come to the order.
My lord, annexure B, my lord.
Yes.
Shall I read from the reasoning, my lord?
Yes.
The plaintiff has filed the suit for seeking relief of specific performance of contract against the defendants, and in the plaintiff has stated that the defendant number 1 is the husband, defendant number 2 and father of defendant number 3. Further, it is submitted that the defendant number 1 to 3 had executed the sale deed in favor of the plaintiff on 27/6/2018 in respect of the suit schedule property for legal and family necessities for total consideration of rupees 27 lakhs. Further, the plaintiff has pleaded that on the same day, the defendant number 1 to 3 received rupees 6,000 through check drawn on Union Bank of India, Coimbatore Nagar, Mysore, and check received in the name of defendant number 1. Further, the plaintiff has pleaded that after execution of sale agreement for urgent need of money, the defendant number 1 on 21/1/2019 approached the plaintiff and executed renewal shara of the sale agreement dated 21/1/2019 by receiving advance amount of rupees 1 lakh through check bearing number 03 so and so, dated so and so, drawn on Union Bank of Coimbatore Nagar, Mysore branch. Further, the plaintiff has submitted that after execution of sale deed and renewal shara, again on 21/11/22, the defendant number 1 approached the plaintiff for urgent need of money and executed renewal shara of sale agreement dated 21/11/22 by receiving advance amount of rupees 50,000 through cash from the plaintiff. Further, it is the case of the plaintiff that the plaintiff is always ready and willing to perform a part of contract, and the plaintiff personally approached defendant number 1 and 3 and requested them to fulfill condition of sale agreement, but the defendant not come forward to execute the sale deed by stating one and the other reasons. Further, plaintiff has pleaded that as per the conditions prescribed in the sale agreement, the defendant number 1 have produced original document with an intention to cheat the plaintiff. Further, it is submitted that as per the condition sale agreement, the period of execution of sale deed is 6 months from the date of production of all the original documents. Further, it is the case of the plaintiff that the plaintiff noticed that the defendant number 1 to 3 executed a bogus sale deed in favor of the defendant number 1 by suppressing the sale agreement and renewal of sale agreement dated 27/6/2024, and the same is not binding upon the plaintiff. Further, it is the case of the plaintiff that the plaintiff got issued legal notice to the defendant number 1 to 4 on 27/11/2024, wherein calling upon the defendants to execute the sale deed. Further, it is stated that now the defendants are trying to alienate the suit schedule property to the third party. On the other hand, the defendant number 1 and 3 denied the contention of the plaintiff and also contended that the defendant number 1 and 3 are the owners of bearing number 40/80 old, survey number 40, bar B measuring 27 guntas. Further, it is the contention that the defendant number 193 had not executed sale agreement as well as renewal shara of sale agreement in favor of the plaintiff. Further, it is the contention that the defendant number 193 had executed sale deed dated 7/6/24 in respect of
Yes,
survey
I've
number.
seen. Please come to the appellate court's order. At page,
My lord, even my lord, the appellate.
page 31, last para.
My lord.
Page 31, last para.
Now the point to be appreciated is that whether the plaintiff is entitled for the interim relief of temporary injunction. Hence, if the material record clearly appreciate that the sale agreement of the sale was executed on 27/6, but the sale, but the said amount of 6 lakhs paid through the cash on 27 with the terms of the sale deed has to be executed within 6 months from the date of receipt of original document. But the plaintiff has issued a notice on 27/11, but after lapse of almost 2 years from the date of renewal agreement dated 21/11/22. These all facts are to be appreciated during the trial. The defendants have also replied to the said notice denying the entire stand of the plaintiff. They have specifically denied execution of agreement of sale for the alienation of the suit scheduled property. The other important facts to be appreciated with regard to balance of convenience, it reveals from the records that the defendant executed the sale deed in favor of fourth defendant on 7/6/2024. And as per the record, the defendant 4 has received 60 lakh consideration amount. Now, if the equity is looked into, balance and convenience lies in favor of the defendant number 4. However, plaintiff has established the right specific performance of contract with regard to the agreement. It is specifically contended by the plaintiff that as per the terms and conditions of the agreement, defendant 103 have not produced original document of the suit scheduled property, but during the matter with the intention to cheat plaintiff, it is to be noted that there is no material record.
Yes, I've seen.
My lord, my respectful submission is that, my lord, sale deed has been admitted, sale agreement has been admitted by defendant number 1 and 2. They are not disputed the signature. They are admitted the acceptance of the advance sale consideration. My lord, the sale agreement is specifically, the condition specifically says that only after production of documents, then the time starts 6 months. Till, my lord, 2024, the defendant number 1 and 3 on repeated request have not made any efforts to produce the document. My lord, once I prove the sale agreement, when I once prove the sale agreement, court should direct the defendants to execute the sale deed. My lord, that being the fact, Supreme Court categorically held that. See, once the sale deed is proved, it's duty bound to execute the sale deed. My lord, that being the fact, my lord, even only because of the defendant number 4 has paid 60 lakh consideration, can it be said that as a bona fide purchaser? The bona fide purchaser should be came to know only after the full-fledged trial. The conduct of the defendant number 1 and 3, the conduct of the defendant number should be know only after trial. Well, without concluding the trial, how both the courts have came to the conclusion that the defendant number, in the event, the defendant number further made any sale it to other persons, then I have to implicate them. Then keep going, same thing, my lord. Therefore, my only respectful submission is now the interim order has been granted, protecting my interest, not to alienate the suit scheduled property till the side of the problem. Therefore, my lord, both the courts have committed a serious error, holding that the defendant number 4 as a bona fide purchaser without full-fledged trial. Therefore, I seek to set aside both the order. Let continue the interim order granted by this honorable court till the trial. Much okay.
My lords, I represent defendant number 1 to 3, my lords.
And
He made a
also,
specific submission.
for a moment, I relied on Supreme Court judgment wherein sale agreement has been executed, subsequent sale had been done. Supreme Court held that that's incorrect. When once the sale deed has been proved, then it is duty of the court. My lord, my lord, 5.2, my lord, 5.2.
Yes.
Please, ma'am.
My lords, may this honorable court be pleased to look into page number 26 of the writ, my lords, the para 11 of the appellate court's order, my lords. It is the contention of defendant number 1 to 3 before the trial court. Further, it is contended that in the year 2018, defendant number 1 to 3 approached the husband of the plaintiff by name A.L. Suresh and seeking for a loan from him for the legal necessities and seeking a loan of rupees 8 to 10 lakhs. During the said period, the Suresh insisted them to execute letter in their favor and had taken them to the office of one Srikant and also obtained the signature of defendant number 1 to 3 on the black bond papers and paid amount of rupees 6 lakhs to check which belongs to the plaintiff bearing number so and so. Further, it is the contention of defendant number 1 to 3 that the said Suresh also gave assurance to the defendant number 1 to 3 to give additional amount. Further, it is submitted that thereafter husband of the plaintiff called the defendant number 3 and gave the amount of 1 lakh through check. My lords, we have not admitted the sale agreement, my lords. We have admitted the receipt of the amount. My lords, further they contend that additional amount was paid, my lords. May this honorable court be pleased to look into the document that they have produced with my lords at page number 94. The document is in Kannada, my lords. Krayada Kararina Munduvarda Shara means it is a renewal agreement, my lords, wherein there is only thumb impression of one of the agreement holders, my lords. Further, another renewal agreement is produced, my lords, at page number 96, my lords. Even there is only the thumb impression of one of the sale agreement holders, my lords. This is the receipt of 50,000, my lords. We have admitted the receipt of the amount, my lords. We have also taken the specific contention that we have repaid the entire amount back to them. The bond papers on which the signatures were taken were not returned to us. This is a matter of trial, my lords. And
what is written on that bond paper?
Bond paper, it is written that additional amount is being paid. On the first occasion, a 1 lakh amount is being paid on our request, and that amount is being paid. And he further states at the end of the that bond paper that the agreement that was entered on 2018 is renewed. 2018 is renewed.
To accept the agreement of 2018 as per?
No, my lords, I don't.
That will be proved whether it is correct or not. But as per this, to the agreement and the renewal one, both there is a signature and you accept the that you have received the money, but you say that the money is received for some other purpose.
We have taken
not
it as
for
a
selling
loan.
this property.
No, we are not.
But the content of the document says, but that is an agreement to sell a particular property.
Yes.
Yes.
Please, my lord, I appear on behalf of the fourth respondent, who is the purchaser of the property, my lord. My lordship, may kindly go to page 33, my lord, which of the order passed by the appellate court, my lord.
Oh, he has read
Which we stopped at that, my lord. My lordship. Page 33.
Yes, I've seen that.
No, only thing is stopped at that, my lord.
No, I have completed the order.
No, considering these factual aspects.
That he has paid 60
as established to go to trial, but this at this juncture, if the prima facie case and balance of convenience is looked into, the plaintiff is not entitled for interim relief.
So what is the prima facie case in a specific
Prima facie case is, my lord, your lordship may kindly see the alleged agreement of sale is on 27/6/2018. And my lord, the terms were that, my lord, regarding the original documents that had to be furnished. My lord, 27/11, no, I purchased the property, my lord, on 7/6/2024. There's absolutely no proceedings between the parties. I purchased 7/6/2024.
There is an agreement of sale which was not in your notice.
No, it's not in my notice, but further, my lord, I lordship would like to bring to your lordship notice, they issue a notice for specific performance on 27/11/2024, after the sale has been executed, not prior to that. My lord, friend is saying it was prior to that. Sorry, my lord, I'm not the purchaser during the time of the proceedings. I purchased prior to that. They issue a notice on 27/11/2024, and they file a suit, my lord, on 9/1/2025. Suit for specific performance. And this particular scheduled property, my lord, was obtained by the first and first respondent in view of the partition deed, my lord, which was effected on 20/12/2023.
All of them, according to them, all of them are signatories to the
No, my
agreement
lord,
of sale.
they are signatory, but what I'm saying is, my lord, the specific performance is filed thereafter. Even the notice has not been issued.
Oh, it is kind of conducting a roving inquiry at the time of injunction application.
My lord,
Whether a suit for injunction is, no, the amount that is accepted, the agreement, anyhow.
Agreement
they,
is the.
No, they only say that out of that agreement, they have received the money, but they say that it is some other purpose.
No,
That's a matter
that
of
I'm
time.
not concerned with that, my lord. As far as I'm concerned, Lordship may kindly see it's under order 39(1) and 2. And regarding this property, which was purchased prior to any of these proceedings, my lord, and your lordship is aware.
What are you going to do with that property now?
My lord, I will have, as an absolute owner, my lord, I have every right to enjoy the property. That is there, my lord. And the question is, my lord, I have paid 60 lakhs. 60 lakhs has been received. And only after the amount is received, thereafter they issue the notice for specific performance. There's nothing, not a whisper at least before that. And this property, what has been, when what is sold, my lord, has been received, acquired under partition deed.
Documents that are filed on behalf of the plaintiff. Where is the plaint? What is mentioned?
Sorry, my lord? The plaint, your lordship would get it at page number 57, annexure C,
Plaint
my
is in
lord.
Kannada.
No, my lord, it's in English, my lord.
Number 40, 51, page number 51.
Page number 51, annexure C, my lord. And they also sought for declaration that the sale is not binding on them. Kindly see the prayers at page 54. Consequential relief. To declare the sale deed, my lord, at page 54, fellowship got it. Direct the plaintiff defendants to execute and register the sale deed. And my lord, they have not produced any documents, my lord, original documents, before the honorable trial court also, before the trial court as well as the appellate court. That has also been recorded in the order which is passed, my lord.
You have issued a reply to this notice dated 27/11.
They issued.
The page number 104 of the written.
What did you say?
The same contention you have taken, my lords. The sale agreement was not executed, and the amount that was paid was paid as a loan, my lords. That same contention you have taken even in the notice, my lords.
Page 109, my lord. 109, annexure 4. Sorry, annexure L, my lord. Which is it's their reply notice at 11, annexure 11 L, my lord, and L1 is the reply. Page 109.
Yes. Please come.
And only one submission, my lord, which is where the fellowship with the trial court order Your Lordship would get it at page 49, my lord.
Yes.
Your Lordship would go to the last paragraph, page 13, para 15 at page 48, my lord. It starts from there.
No,
I'm
I have
going
read
to
this
rival
para. What you
contention.
want to, what is your submission? I've read the para.
Yes, my lord, it says, my lord, if I read further, the further, as per the allegation of the defendant amount through in their objects, the plaintiff's great sale agreement by missing the signboard received during the time of advancing the loan of the number by defendant by husband of the plaintiff without verifying the document property during the year 2018 and going through condition of the reveal the discrete property is disputed by defendant number 3 further and perusal of the sale deed dated 7/6/2024 submitted by the defendant by the plaintiff number 13. Family members acquired the suit property in 2012. That, my lord. And one more thing, my lord, if your lordship would go further down, further in praise of the sale agreement renewal, it appears that if anyone only signed the papers, hence it revealed that the plaintiff has not approached the court with clean hands. Further, whether defendants are having right over the suit title property during the year 2018 or not is a matter of trial, and also is not dated 27, and the sale agreement has been created also and also
Either
a
you
matter
want
of
an
trial.
injunction or a status quo.
Sorry, my lord.
Either shall I grant injunction or status quo? Either of it you want, but I'm going to allow the writ petition.
My lord, when both the courts have.
You argued that is over.
Please,
Now
my
I'm
lord.
asking either you want injunction or status quo.
My lord, one submission, my lord. If your lordship is intending to grant status quo, let the suit be decided expeditiously within a period of 6 months.
Suit
My
of
lord,
2025.
no, my lord, what happened? One year, my lord, from last year, the matters were for trial and that they have not commenced trial. There's no stay from any of the courts. So within 6 months, my lord, of these
You
31st
can't
December.
grant such a direction for a 25 suit when there are several suits pending on the file of the court.
No,
Please
my
can't.
lord, my humble submission is that, my lord,
Can't for the Supreme Court says you can't file that, pass that kind of orders to the family, to the courts. Please
no,
come.
my lord, because I do understand, my lord, but here in this a suit, my lord, where
To any
that's
of the
one trial.
courts, we can't pass any order that's
From
order of
1
the
year is
Supreme Court.
for 1 year is for their evidence. They have not come forward.
Let it be.
Your lordship may kindly
Agreed.
fix the time at least, my lord.
I cannot fix, that's what I'm telling you.
My lord, they would just drag on as has the house has been dragging on.
I think you understood. Please, agreed with the orders passed.
The agreement was not registered.
And one more submission, my lord, the agreement of sale is not registered. That also may be taken, my lord, is what happens, my lord, fellowship is granting status quo and disposing the petition. My lord, all the contention what have been taken by this honorable court would be again, my lord, it would be a bearing on that. So none of the contention to be, all the contention be to be left open.
It
my
will
lord.
always be open.
Please, my lord.
Whatever observation, that should be for the limited purpose of passing orders in this. Agreed with the orders passed in MA number 26 of 2025 by the 6th Additional Senior Civil Judge and JMSC Mysore. Mysore, the notice number 83 of 2025, whereby it has confirmed the order passed by the trial court in IA number 1 in notice number 83 of 2025. The 6th Additional Senior Civil Judge and JMFC Mysore, the petitioner who is a plaintiff before the trial court, who is a plaintiff is before this court. Then comes the petition herein has filed a suit for specific performance of the agreement of sale dated dated 27 to what is the date? Agreement of sale.
Lord, agreement of sale, my lord.
It's 27/6/2018, my lord.
27 6 20 27 6 2018.
Please.
And it is a case of the plaintiff that the defendant number 1 and 1 2 3 have executed an agreement of sale, and thereafter when they have failed to execute a regular sale deed by producing all the relevant documents, he has issued a notice to them and thereafter filed the instant suit. Along with the suit, he has filed I number 1 under order 39 rule 1 and 2, seeking injunction restraining the fourth defendant from alienating the property. That came to be dismissed by the trial court by order dated 27 February 2025. While dismissing the application, the court has observed that it is a contention of the defendants that the plaintiff has created the sale agreement misusing the single bond papers received during the time of advancing loan to the defendant numbered 123 by husband of plaintiff without verifying the document of the property during the year 2018. And also the court observes that the registered sale deed is dated 7/6/2024, executed by the defendant number 123 in favor of defendant number 4. It is the family members have acquired the property on 2012-2023 under the registered partition deed. But the agreement of the sale is of the year 2018. When the description of the property is denied by the defendants and it is not justifiable to grant temporary injunction against the defendants. Further, on perusal of the sale agreement renewal shara dated 21/1/2019 and 21/11/2022, prima facie it appears that the defendant number 1 only signed the documents. The court comes to the conclusion that the plaintiff has not come to the court with clean hands and accordingly rejected the IA that's filed seeking injunction not to alienate the property. Agreed thereby that the petitioner has filed MA number 26 of 2015. The appellate court has also confirmed the order of the trial court. While confirming the same, the court observes that the petition has sought for a specific performance and also a declaration that the sale deed executed by defendant number 123 in favor of defendant number 4 is null and void. These reliefs have to be granted to the plaintiff on establishing the right by the plaintiff. At this juncture, though there is a prima facie case in favor of the plaintiff, and there is a agreement of sale executed by defendant number 123 in favor of plaintiff, and there are 2 renewal agreements, but these are the tribal issues. But balance of convenience does not lie in favor of the petitioner, as the sale deed is already executed in favor of defendant number 4, where he has paid 60 lakhs to the defendants 1 to 3 on execution of the sale deed. Even if the interim order is not granted, irreparable injury will not cause, which cannot be compensated. Hence, the court has come to the conclusion that the 3 ingredients to grant the interim temporary injunction are not available to the plaintiff. Hence, considering the facts and circumstances, the plaintiff is not entitled to the relief of temporary injunction. And the appellate court has held that the trial court, after appreciating the material on record, has passed an order and there is no reason or grounds to interfere with the order of the trial court and accordingly dismiss the MA. Agreed thereby the petitioner is before this court. Land counsel appearing for the petitioner submits that when the respondents have admitted about the amount that is paid, and when there is an agreement under renewal agreements, now they have taken a stand stating that they have not entered into any agreement, and the petitioner has made them to sign on those papers. All these matters have to be decided by the court during the course of trial. But at this juncture, the trial court cannot go into all these aspects, and prima facie, the petitioner has made out a prima facie case. If during the course of during the pendency of the trial, pendency of the case, if the fourth respondent alienates the property, it would lead to multiplicity of proceedings, and this aspect was not considered by the court. It is submitted that the defendant 1 to 3 selling the property in favor of defendant number 4 cannot be considered as a balance of convenience in their favor, and the counsel submits that the court has failed to consider the fact that the petitioner satisfies the 3 ingredients and is entitled for the relief as prayed for. Next parallel, and counsel appearing for defendant number 1 to 3 submits that the court has rightly considered the fact, and the counsel points out at the renewal agreement wherein only the one of the agreement only one of the parties thumb impression is present. It is submitted that they are denying the execution of the agreement of sale. As such, the court has rightly dismissed the IA. Next parallel, counsel appearing for the respondent number 4 whose purchaser submits that the notice is also issued after execution of the sale deed. As on the date, the petitioner has, the defendant number 4 has purchased the property. No litigation is pending and is a bona fide purchaser by paying a valuable consideration of 60 lakhs.
60 million.
60 lakhs. And this court, as the trial court has taken note of this fact, and the appellate court has confirmed the same. And in these circumstances, there is the orders passed by both the courts are well considered orders. This court, and there are no reasons to interfere with the same. Expect having with the counsels on either side for some material on record. The suit is filed seeking specific performance and cancellation and a declaration that the sale deed is not binding on the plaintiff. In this case, according to the plaintiff, there is an agreement of sale and he has given certain amounts towards the sale consideration. According to the defendants, they have received the sale consideration. They have received the consideration, they have received the amounts. But however, it is their case that they have taken it as a loan. And
Only a partial amount, madam. Only a partial amount.
they have taken the amounts
Of only
as
6
a loan.
lakhs.
Whatever amounts that are given
Partial.
are taken as loan. And they have not executed any agreement of sale. That is a fabricated document. These issues, whether it is a fabricated document or not, will be considered by the court during the course of the trial. Mere denial by the defendant itself cannot be a factor for the court to consider while considering an application filed under Order 39, Rule 1 and 2. The acceptance of the money as stated by the petitioner in the plaint is accepted by the defendant. However, they say that it is not for the purpose of selling the property, but for something else. In those circumstances, all these questions have to be decided. The trial court and the appellate court has gone on a premise that already 60 lakhs is paid by the defendant. As such, the balance of convenience is in the favor of the defendant. The court, the said finding cannot be cannot be sustained for the reason if there is an agreement of sale according to the plaintiff, if the defendant sells the property and it is purchased by a fourth respondent, and that cannot be a ground to reject the application that is filed by the plaintiff. The whole purpose of this injunction petition is if the fourth respondent alienates the property and it would lead to multiplicity of proceedings, and to preserve the sue scheduled property, the interim injunction is very much required in the facts and circumstances of the case. Status quo injunction.
Sorry, madam.
Status quo injunction.
Status quo, madam.
To preserve the property is very much necessary. When this matter came up before the court for preliminary hearing, a coordinate bench of this court has granted an order of status quo on what date?
5/11/2025.
5/11/2025, and the said order is continuing till date. Hence, in the facts and circumstances of the case, this court deems it appropriate to pass the following order. The order passed in MA number so and so and in I number so and so was set aside. The IA filed by the IA number 1 filed by the plaintiff is partly allowed by directing the parties to maintain status quo accordingly disposed of. This court has not expressed anything on the merits of the matter, and any of the observations made in this court shall not be construed as an expression of this court. The court shall decide the matter on the merits of it. All the contentions are left open.
But it may be disposed of expeditiously, madam. That's at least the word used, expeditiously, madam.
No.
It can be used.
Number 10.
Appear for I appear for the petitioner lots. The suit was, the petitioner lots or the was the plaintiff, and the suit is for declaration and other reliefs, my lords. The impugned order, my lords, is at Annexure A, page 19, relevant portion at page 20. It is, my lords, an application filed by the petitioner, the plaintiff, under Order 16, Rule 1, my lords, to summon two witnesses. One, the bank manager, and another, my lords, the town planning member of the BDA, my lords. If your lordships look at Annexure A, my lords, there was no objections, my lords, by the defendants. A simple order, my lords, on the same day we filed the application.
Where is the
Page
impugned order?
20, my lords. Page 20 is the relevant portion. Page 19 is the Annexure A. Page 20, counsel for plaintiff present and files IA number so-and-so under Order 16, Rule so-and-so. Today, the case is posted for cross-examination of DW3. However, counsel for plaintiff files IA number so-and-so to issue witness summons without cross-examining DW3. No grounds made out for relying so-and-so. Hence, it is rejected. My lords, could I take your lordships to the background of this case, my lords? This matter, my lords, there was a dispute with regard to the land being acquired by the respondent society, my lords, in which the original owners had executed sale deeds in respect of the vendor of the plaintiff. That is the petitioner hearing. My lords, it culminated in an order of the division bench of this honorable court, wherein this honorable court, my lords, specifically directed the society that it should not evict any member of that. So there was one more society, my lords, that was formed by the purchasers from the original owner. So this honorable court in the division bench directed the society, the respondent society, not to evict any of these people without due process of law. My lords, pursuant to this, the society files a suit, my lord, seeking for possession from the vendor of the petitioner or the plaintiff. During the pendency of this suit, my lords, for possession, it sells away the property to somebody else, my lords, giving a different site number to this, my lords. And as an application for injunction is filed, I'll take your lordships just to that application, that order at page 121, my lords. This is the order, my lords, on an application filed by the society in the suit for possession filed by it, my lords, against the vendor of the plaintiff. My lords, it is at page 121. The plaintiff is a house cooperative society and it has filed the suit seeking for a relief of possession and permanent injunction in respect of the suit residential site. The documents produced by both the parties at this stage goes to show that the sale deed dated so-and-so was executed in favor of defendant number 2. The plaintiff's contention is, my lords, if I just leave this para, go to para 8, in the writ petition filed in WP number so-and-so by the plaintiff society.
Your injunction is granted in your favor, yes.
It was refused to be granted to the society. My lords, the dispute in this matter is whether the society, my lords, through the BDA has got the layout formed and it could, my lords, kindly see this para, my lords, para 10, page 124, which is very relevant for me. Admittedly, the suit has been filed by the plaintiff. Plaintiff is the society for possession and permanent injunction in respect of the suit scheduled property, but as claimed by the plaintiff society themselves in their objection statement, they have already sold the property in favor of one H.C. Basavaraju, that too in the year 2021 during the pendency. My lords, your lordships may appreciate the society files a suit, my lord, seeking for possession. When the suit for possession is pending, they sell the property, my lords, without even having possession of the property, they sell this property. Now the dispute, my lords, or the matter in issue in this suit filed by the society, which is clubbed, my lords, with the suit filed by the petitioner herein, is whether the plaintiff, that is the petitioner, is in possession of the site that was sold to her by the original owner of the land, or the society has formed a layout, my lords. That is why we are summoning, my lords, the town planning member of the BDA to give evidence whether such a layout has been formed or not. My lords, without even applying its mind, simply, my lords, the Honorable Court, my lords, the background of this case again, my lords, is there is an order by this Honorable Court in MFAs, my lords. There was an injunction that was refused and granted in my favor, which came up in MFA before this Honorable Court. This Honorable Court, my lords, directed that the suits, both the suits were clubbed and they should be disposed in a time limit. My lords, if the time limit is granted by this Honorable Court, my lords, the civil judges hurry up the matter. They don't give us adjournments even on genuine reasons, and they just hurry up the matter, my lords, passing such orders. This is one such order. My humble submission is just this, my lords. We require the town planning member only to give evidence. My application, my lords, is at page 173. Affidavit, my lords, is page 125. 174 is whom I am calling as witness, the branch manager and the town planning member. I will not trouble your lordships at page 170. My lords, there is a specific denial, my lords, by the witness that there is no layout. That is why we have called them at this stage. Para 7, my lords. I state that in view of the above, it is only logical that without going through the rigors of appointing a court commissioner, it may be more, page 177, my lords. As such, it is most imperative that the town planning member, Bangalore Development Authority, be summoned to tender evidence in the matter surrounding questions pertaining to the very formation of any layout in the land and survey number so and so. My lords, without any...
But it's rather shocking, my lords. Miscellaneous first appeal was considered. At the first instance, what should have been produced along with these papers is the orders passed in the miscellaneous first appeal. Because the direction issued was by consent. Lords, there are two suits filed.
It was not by
One
consent.
is a suit filed by... I was appearing in that matter. I'm aware as to why this order was passed. But two suits are filed. One is by the writ petitioner. Writ petitioner's contention is that the property which is subject matter of her sale deed was not the subject matter of an acquisition. Just a little years back, I'll go, my lords. Various properties were acquired for the benefit of a cooperative society. Acquisition proceedings came to be challenged. The acquisition proceedings came to be upheld by the learned single judge. Matter was taken before the division bench. Before the division bench, some people claimed that they had already put up constructions in some portions of the acquired land and that they had formed an association and therefore their possession should be protected. So what the division bench did is, it said, all right, I can only ensure that your possession will be taken only by due process of law. That's the only limited protection given. That means the factum of acquisition having been completed and that the acquisition has been for the benefit of the society got concluded up to the division bench with only a leverage saying that if somebody is actually in possession by putting up a construction, then their possession is protected from forcible dispossession, but they can be dispossessed through due process of law. Other than that, nothing was there. Now, it's a very mischievous argument which was canvassed. Now, the suit is something else. Suit is not regarding whether this is plan is there, not there. That's not the suit. Kindly have a look at the plaint. I'll just come to that, Vinods. I'll just come to that because I'll just another 3-4 sentences. I'll complete my submissions on the history of this case and then go to their conduct. Vinods, what happens? I'll point out, Vinods, can I just pass on the copy of the MFA order? I just take that to your lordship's notice and then tell the court as to.
It is irrelevant for the disposal of this case.
Vinods, I just point out, Vinods. The reason is a statement being made that the court was in a hurry is rather startling. The reason being the directions was given in September 2023 to conclude the proceedings within 8 months. In 1 year they have filed 25 applications. I'll just bring to your lordship's notice how many applications they filed, including the applications for summoning of the witnesses.
But that is not necessary because I'm not going to take note of those submissions.
The conduct of the party is to be looked into for the purpose of your lordship's exercising 227 jurisdiction.
No, let's look at the impugned order first.
Lordships your lordships have seen the impugned order. Lords, impugned order says no grounds are made out.
Where is the discretion?
Lords, that's the reason why I said, Lords. Now, it is at the stage of cross-examination of DW3. Lords, once the stage of plaintiff's evidence is completed, and they want to file an application saying that, no, I want to summon the witnesses, the stage should be for the plaintiff's evidence. That was not the stage. There is no question of jumping the stage. Lords, what the plaintiff wanted to do is at the fag end of the trial, I just take your lordships minutes to few facts indicating what is their conduct before the trial court. Before that, can I just persuade your lordships, because whoever is sought to be summoned, they should have some relevance in the manner in which they have put forth the case. Lords, that's the reason why I said, Lords, if the court says no grounds, there are at least a dozen number of orders passed by this very court where they made applications to include these particular parties to be impleaded. They had earlier filed applications seeking summoning of the witnesses. It was allowed. They did not take process. Then they started filing memos saying that we are not interested in summoning these witnesses. Like this, one after the other applications, 25 applications in 1 year. What is it the trial court is expected to do, my lords, when such?
Court is expected to write order.
Lords, kindly have a look at page number 120.
The reasoning of the court cannot be supplemented by arguments.
Lords,
Court has to understand from the order what is the intention of the court and what is the reason for the court to pass such an
Lords,
order.
can I just persuade, my lords? If a
Whole problem, she wants me to look at something, you want me to look at
I'm not,
something.
Lords, I'm only saying,
But I have to look at the order.
Lords, your lordships is looking at the order passed in a context. Lords, it is not that this order is passed not out of context. We are in a context where plaintiff comes to the court saying that my property is not subject matter of acquisition. That is her contention. Lords, I just, because if the application fits into her case, there is something to be discussed.
To say that.
Lords, that's the reason why I am submitting, Lords. The court has passed these orders umpteen number of times.
That also court has to say.
Lords, that court, Lords, we have produced the earlier orders of the court where this very issue is discussed.
We will not be reading here and there to understand.
Lords,
what is
now the difficulty for us is this, Lords, if this is the manner in which the court proceedings are being dragged, despite the order passed by this honorable court in September 2023 to conclude the trial within a period of 8 months. Where do we stand at this juncture?
That is what repeatedly I was telling the judicial officers. If that is the case, whatever you are submitting, that conduct should be reflected in this order.
Lords, there are earlier orders passed. That's the reason why I said, Lord, this is an application dismissed with a cost. If cost is imposed, earlier orders, your lords may kindly have a look at too. The court has recorded enough and sufficient reasonings to say that the conduct is only to protract the proceedings throughout.
Do you find that in the present order? No, because
that is not there, my lord. Your lordships have.
With the present impugned order. Where is that order?
Annexure A, my lords, page 20.
Yes. What exactly the court was saying in this order?
Page
no
20.
Grounds made out for economic IA.
Lords, kindly have a
Every order goes like this.
Lordships may kindly see the stage is for cross-examination of DW3. Application is filed under Order 17 seeking adjournment. Then, this is 20. Counsel for defendant present, counsel for plaintiff files IA number so and so. Today the case is posted for cross of DW3. Counsel files IA number so and so issued to witness summons. No grounds made out to allow. Hence, IA number so and so filed by plaintiff is rejected. Counsel for plaintiff proceeds for cross-examination. Again, cross-examination is adjourned as a last chance. Now, this is essentially what I said. If the stage is not for plaintiff's evidence, where is any question of entertaining this application by the trial court? Lords, your lordships under 227 is under a corrective jurisdiction, lords. Now, if a direction is already issued by this honorable court, 25 applications are filed and rejected, all rejected by imposing exemplary costs. Now, if the application is filed at a stage when it could not have been entertained, and they can't challenge the orders before this honorable court because that was not the stage for the filing of an application. That's essentially where it stands, my lords. Now, if your lordships were to see it's for cross DW3, it's at the fag end. Lords, I'll just indicate, my lords, what is the conduct of this and leave it at that. Lords, can I just pursue it, my lords? Your lordships may kindly take that volume, my lords. I'll quickly run through, my lords. I understand the time constraints. My lords, on 31/7/24, they filed an application seeking summoning of witnesses. They wanted to summon the High Court Registrar and 2 other witnesses. Page number 9 of the volume of documents which I have given them, my lords. Lords, in this, the application was allowed in part, permitting them to summon 2 witnesses at page number 15. Lords, this is an order passed on 31/7/2024. Lords, this exercise of summoning the witnesses has already been undertaken. Next, Lordships will see at page number 16. On 9/8/24, the last paragraph. Not even the process is paid. Lords, therefore, this order, last two lines, the plaintiff is dragging the proceedings in this case. Last two lines, my lords, in this page. He is dragging the counsel of the plaintiff is, instead of keeping the witness present, questioning the issuance of summons to witnesses. Hence, witness 2 and 3 are dropped. So, witness 2 and 3 to whom it was dropped. Then what they do? Kindly have a look at page number 24. Lords, they filed one more application seeking recalling of these orders at page 24. Sorry, my lords. I stand corrected. They filed an application seeking stay of the suit because there was another writ petition pending. That was dismissed with a cost of 5,000 at page number 25. Observations, my lords, is that they are dragging on the proceedings is made at paragraph number 10. And then, if your lords were to kindly come to page 26. They filed an application to recall the order dated 9/8/2024, where that witness summons order directing the dropping of these witnesses was passed on 9/8/2024. Counsel for defendant 2 and 3 submits that he has no objection to allow. It's allowed on a cost of so and so. Process server is directed to serve the witness summons immediately as the case. There is a direction by the Honorable High Court. This is an order which has been passed on 27/8/2024. And then Lordships may kindly have a look at the next page, 26. I'm sorry, 27. The order sheet dated 11/9/2024, that is the second entry, bottom of the page at page 27. Counsel for the plaintiff files a memo dropping the witness number 2. They are playing around with the court proceedings. Then page number 31. At the bottom of the page, my lords, in page 31, which is the order sheet dated 13/11/24, summons no representation made, counsel for plaintiff absent, summons issued to witness number 3 to RPID returned unserved, counsel for plaintiff not received the hand summons to witness number 3 kept by. Then next, this is a direction of the court for so and so. Even knowing the directions, even providing sufficient opportunities, counsel for plaintiff is not secured witness. Witness number 3 is dropped and further evidence of the plaintiff is closed. So this order has become final. Plaintiff's evidence is closed. And then page number 32. They again sought for recalling of that order. 13/11/2024. That is rejected. This order has become final. And then again on 20/11/2024, they file one more adjournment application seeking 2 weeks' time. Then your lords may kindly take page number 48. Lords, one of the witness who is sought to be summoned is the manager of Union Bank of India. Bottom of the page, my lords, on 21/7/2025, IA number 1 of 25. Counsel for plaintiff filed IAs and so and so to seeking permission to implead. That is rejected. That is dismissed. This order again has become final. Plaintiff's evidence is closed, has become final. And then page number 66. Again, they filed an application saying that the suit has to be stayed. That is again dismissed, saying that the earlier this has already happened. Then next page, my lords. Again, adjournment applications are filed. Lords, in all there are 25 applications. The petition is before the court in respect of IA number 21, all filed by them. And these are the kind of applications which has been filed.
Now, when your evidence is closed, how will you examine him?
My lords, kindly see order 16 rule 1, my lord. Any order 2, a party desirous of obtaining any summons for the attendance of any person shall file in the court an application stating that therein the purpose for which the witness is proposed to be summoned. My lord, see,
You want to examine him as your witness.
We will file an application to recall that order, my lord.
Tell me,
Once this
why the
application
court-
is allowed, my lord, this
No, no.
application needs to, yes, my lord. Yes,
No,
ma'am.
that is
Yes.
first and this is second. Unless and until your evidence is again
Reopened.
reopened, then only this application is maintainable. And in their, when their evidence is going on, without filing an application to reopen your evidence, how can you maintain the application?
My lords, that I'll find out.
What will you do by summoning the witness?
My lords, they are to give evidence, my lords, only with respect to the certain aspects, my lords. If that was the reason, my lords, we would have filed an application immediately and that would be allowed. My
Defendant's witness or your witness?
It is the court, my lords, we filed this application because we did not want appointment of a court commissioner. In this matter, my lords, there is a serious fraud that is being played by the society, my lords, in spite of division bench orders that possession should be taken only in due process of law. The society.
Now the suit, you have filed an independent suit, you have availed a remedy
Yes,
which is available to you. Then the court, you have to let the court decide all this.
Yes, my lords, let the
And
court.
these kind of petitions, without even asking for reopening of your evidence, filing the applications and
My
coming
lords,
to the
this
High
is
Court.
just an application. Well, my lords, we could have filed the application also.
Why should the suit be stayed? Why you file applications for
My
staying?
lords, why the suit was to be stayed was, I will tell my lords, my learned friend has now just given me these things. If your lordships, the suit was to be stayed because there is a writ petition, my lords, that is pending before this honorable court, where Katas, my lords, issued in respect of the entire layout, which is supposed to have been formed, my lords, by the society, is stayed. And the sites are not released. My lords, because of that, we have filed an application to implead ourselves in that petition, and that's why we have stayed, sought for stay, my lords. Because, my lords, they have the site by which form they have sold, my lords, to the respondent. That site itself is not in existence, my lords. Such a site itself is not formed. That is why we have filed, my lords. That's all. My lords, application to recall, I'm not sure, my lords, whether the application has already been filed or not. This.
2025, asked in notice number 1564/2022, pending on file of the so-and-so, dated 28, what is the date of order?
28/11/2025.
28/11?
11/2020. 28/11/2025.
5 minutes.
28/11/2025. The IA that's filed under order 16 rule 1 and 2 to issue witness summons to a bank manager and also a officer of the VBMP. Who is that?
Town planning member, my lords. It's at page 174, my lords.
To the town planning member. The court, while discussing the application, observes that the counsel, the court observes that the counsel for the plaintiff has filed IA to issue witness summons. No grounds made out for allowing the IA. Hence, IA filed by the counsel of the plaintiff is rejected. Counsel for plaintiff raised time for cross-examination of TW3. Call on for cross-examination as a last chance by 29/11/2025. Then counsel appearing for the petitioner submits that the court had failed to consider the application that is filed by the petitioner seeking to issue summons to the said witnesses, as examining those witnesses is very much crucial to the case of the plaintiff. And the order that is passed by the court is bereft of reasons, and the same requires to be set aside, and an opportunity shall be given to the petitioner to summon those witnesses and examine them to elicit the truth and the correct facts, which is very much essential for the petitioner to prove their case. Next paragraph, senior counsel appearing for the respondent defendant submits that in the year 2023, an order is passed by an MFA by a coordinate bench of this court, directing the trial court to dispose of the matter within a period of 6 months.
8 months.
8 months. And from there on, the petitioners herein have filed multiple number of IAs and keep on dragging, and they are dragging on the matter. In fact, earlier they have filed an IA to impede the bank manager in the suit that came to be dismissed. It is
No,
also
my lords.
submitted.
My lords, we're not dragging on the matter, my lords. All these applications were necessary. Because I did not reply to it. I'm sorry. I'm sorry.
The IN, what did you write? It is submitted that after the said application is dismissed, now they have come up with the present application. The senior counsel has drawn the attention of the court to several proceedings, the order sheets, and how the matter is tracked. It is the submission that, considering all this, the court has dismissed the application. Hence, there is nothing. Hence, there are no grounds to interfere with the order passed by the court. Next question. We have the counsel for the petition, the senior counsel responded. There is a material on record. What is the conduct of the party and how the matter has been dragged on, and the court, as far as the order impugned is concerned. Any grounds for such an order passed by the trial court cannot be appreciated. When an order passed by the court is an order appealable, revisable by the superior court, the court has to record the reasons for the same, so that the court will understand what is the reason, on what grounds the court has refused to grant a relief to the party, and any amount of submission by any of the parties cannot supplement the view of the court if are submitted by the senior counsel. If the respondents or if the petitioners are repeatedly filing the applications and dragging on the matter, the same would have been discussed by the same should have been discussed by the court in the order. But the court cannot dismiss the applications in this manner. It is also when this court has asked and counsel the petitioner whether any application is filed seeking to reopen the evidence of plaintiff, it is submitted that such an application is not filed.
My lords, I'm not sure. My lords, I am not appearing in the trial court.
Not there. Making a statement on from the order sheet. It's not there.
I'm not sure, my lords. I'm sorry.
But the order sheet, then counsel submits that she has no instruction. But
Yes,
however, the order sheet does not disclose that if any such application is filed. If the court has to give reasons for such a dismissal without filing such an application to reopen the case, they cannot ask for summons, cannot file this application seeking a direction to issue summons to the witnesses. When an order is passed for the court for an expeditious disposal of the matter, it is the duty of all the parties that that they have to cooperate with the trial. This is a suit of the year 2022, and it from the submission of the land counsel, the senior counsel, the respondent, and direction was issued to dispose of the matter within 8 months. But even till 2026, the matter is still pending. In fact, by passing such an order, the court has added to this, wherein this court is constrained to set aside this order. Hence, as the same is bereft of reasons. However, it is made clear that the parties shall cooperate with the trial, and the court shall whenever an order is passed, shall pass an order containing the specific reasons for such refusal or for allowing the same. And that is the matter. The order impugned dated so and so is set aside, and the matter is remanded to the court, and the court shall pass appropriate orders.
It's within a period of 1 week, my lords.
Within a period of 1 week from the date of receipt of the copy of the.
Lords, can I also further request, let the trial court may take up the matter on day-to-day basis and conclude this matter. Lords, if there is a direction for concluding these proceedings by the.
That is there from the MFA that court will.
Lords, now that your lordships have observed that even the trial court has added to the misery, my lords, or the woes of this litigation despite the direction. Lordships may have to give a direction, my lord, that the trial court has to.
That I've already said that the court should, as per the orders passed in the MFA, the court shall make all the endeavor to dispose of the matter at others.
Please.
Yes.
Number 11.
Grateful. Great.
Vachan?
Serial number 11, I appear for the petitioner's minutes.
Yes.
My lords, one indulgence, my lords. My lords, I appear for the respondent, my lords. I filed my NOC Wakalatnama yesterday, my lords. I just seek a short accommodation, my lords. On Friday, my lords, I'll just.
Once this matter is out of the list for next 2 months.
My lords, no, my lords, there's some urgency, my lords, in this matter.
Either you argue today or it will go in the month of August.
No, my lords, there's a urgency, my lords. The only.
But the court has no, because we can't accommodate the matters. That's the
I'll
reason
just
why I'm
place
saying.
my submissions, my lord. Since if a document is there, my lord, I just seek the indulgence to accommodate for a document to produce, my lord.
What document is required in
Because
this?
what happens is, my lord, the petitioner.
CPC matter, whatever are
Please.
the documents that are here.
Grateful, my
We
lord.
will not be looking into any other document.
Grateful, my lord. The impugned order, what is being challenged, my lord, it is only for the implementation of the order which was confirmed by the Honorable Supreme Court. So that order, my lord, I file and.
We will see what it is.
Please.
Yes.
My lords, as my learned friend requested, I have sent the senior. Pass over, my lords, afternoon we will argue. Because she requested, I asked the senior to go. So afternoon we will argue the matter. So I'm seeking for a password.
Grateful.
Number 12.
Would I appear for the petitioner?
Arun Govindraj?
Yes.
Lord, this is a defendant's writ petition challenging an order of the trial court allowing the plaintiff's application to amend the plaint after the plaintiff has been cross-examined. The
What is the suit for?
Suit is for specific performance.
Which year is the suit?
2022.
No, by way of this amendment, what are the pleadings introduced?
No, he wants to delete paragraph 7 of the plaint where certain admissions have been. Sorry, Lord.
Please come to the affidavit.
Lord, may I make this the cross-examination is all in Kannada.
Not the cross-examination. I'm saying where is the affidavit that is filed?
Yes,
in support of the IA.
65.
Page 65, my lord.
65.
Page 65. Para
Just
3.
one paragraph.
11.
May I read paragraph 3, my lord? I submit that the plaintiff has pleaded in his plaint about payments details made by the plaintiff to the defendant due to an inadvertent typographical mistake in para 7 and column number 2 to 5. The plaintiff has shown the amount paid by the plaintiff of sum of 65 lakhs, wherein the plaintiff has paid at 25 lakhs. Therefore, it is necessary to amend as sought. Further, the amendment sought does not change the nature of the suit nor cause of action, hence the accompanying application. Now, in the cross-examination, he admits that the payment is made as averred by him in the plaint. That is the admission in the cross-examination.
We'll ask him.
Yes.
My lord, this is a suit for specific performance. The total consideration, there is no dispute, 6 crore 15 lakhs. Total consideration. The amount of paid, already paid as an advance, there is no dispute. That is in para 7 at the end, 5 crore 34 lakh. Kindly say page 33, my lord. Plaint. Plaint start at page 30. Para 7 is at 32 and 33 it continues. What I wanted to, I'm saying the typography mistake is in para 7, there is a column wise payment details I have mentioned. How I have made the payment of 5 crore 34 lakh 81,150 total amount. Your Lordship may kindly see 2, 3, 4, 5. I have mentioned 65 lakhs and the two check payments, ICICI, HDFC. What actually it should have been is not 65 lakhs, 25 lakhs. Now your lordship may kindly see.
Where is it? 1, 2, 3, 4, 5.
2, 3, 4, 5. One is cash.
Hmm.
2, 3, 4, 5.
Hmm.
This should have been 25 lakhs, not 65 lakhs.
It's by way of cash.
That is by actual payment paid through check. It is not cash payment.
Then in that case, how this will become?
Now your lordship may kindly see, if we take at 65 lakhs, the amount will be paid by me will be totally amount of what I have mentioned details. It will become 6 crore 94 lakh 80,000, which is more than even sale consideration, admitted sale consideration of 6 crore 15 lakhs. Whereas if it is taken as 25, then the total what I have shown in page 33, your lordship may kindly see, 5 crore 34 lakh 81,150. This is correct.
The amount will be the same.
Same. That amount will not change. Now kindly see the return statement. It will not change any admission, or it will not change the cause. Kindly see para 3 of para 2 of the return statement, page 40. In para 2, first after first sentence, second sentence, the suit scheduled property consists of two distinct but adjacent sites. The agreed sale price was rupees 6 crore 15 lakhs. He also admits, defendant also admits. Out of that, I said that 5 crore 34 lakh 81,150.
What is the amount he says that what he has received from you?
That nowhere he disputes that he has received 5 crore 34 lakh 81,150. Nowhere he disputes.
That is not denied.
That is not denied. Now, on the other hand, para 3 of page 41, your lordship may kindly see. One vague sentence he says, and in the last 3 lines, para 3, the parties agreed that the period for conclusion of the sale transaction would stand extended in terms of the sale agreement to 3 months from the date so and so. The governments in para 7, more particularly, claim to have paid sums as detailed in the said paragraphs are denied by the defendant. Because I have said 65 lakhs, he has denied that. Yes, I also agree. And now I have produced the agreement. Your lordship may kindly see that.
Yes, Mr.
No, all of my yes, I've seen para 8 of the order. Yes.
Please read.
But I'll just.
Page 19.
Yes.
Paragraph 8. I'm sorry, Lord.
Yes, I've seen it. I've seen it. I think there is nothing in this order. Court was right in allowing.
The ground, Lord, I would like to urge before my Lord is, kindly see, after Amendment Order 6 Rule 17, the proviso makes it a mandatory provision for court to allow, my Lord, amendment only if there is, despite due diligence, this was not done.
I can understand by altering this, by allowing him to correct this mistake, the entire amount what is paid to you is changing. It is not changing. It remains to be the same. And the money what he has paid is by way of check. Check the amount will be mentioned, which can be substantiated by him during the course of trial. There is nothing like taking away any admission or changing the nature of the suit, nothing.
No, the cross-examination. No, in the I will only, if your lordship permits me, only one line in the cross-examination. No, in the cross-examination is asked.
What he says is, he has paid 5 crore and odd. Now, if all these amounts are calculated, it would be more than that. That is where now, even if it is his case that it is by way of cash, we can understand. He has given it by way of check. That can be that he will prove it in the
and in exhibit in P1, P2, it is mentioned. Check number, amount, everything mentioned. Date, all tallies.
Now, there is an admission in the cross-examination. I have made the payment in terms of para 7 of the plaint. That plaint is now sought to be amended.
Para 7 of the plaint is 5 crore 60 lakhs so and so.
No.
Now,
the payments made, the list of payments. The list of payments made.
List of payments, that's what the list of payments. If you calculated it at 65 lakhs, that's what he is saying. It will become 6 crore and odd.
Yes, madam.
But what he paid is 5 crore and odd.
Page 54,
agreed by the orders passed in I number 9, invoice number 359 of 2022.
Page 54, if your lordships could see. That is what Mr. Arun Govindraj is pointing out. He says
it's in Kannada.
$65 lakhs was paid.
It's in Kannada.
says in cross-examination that he has paid 65 lakhs on 4 occasions.
It's not 25 lakhs,
Okay.
it says paid 65.
I understand. I'll record the submission. Agreed with the orders passed on I number 9 in OS number 359 of 2022 dated 10th February 2026, whereby the court has allowed an application filed by the plaintiff seeking amendment of the plaint. The defendant is before this court. The respondent herein has filed a suit for specific performance. Specific performance of agreement of sale. In the plaint, it is stated that he has paid and he has given a table showing that what are the amounts that are paid by him. At page 32, paragraph number 7, there is a table. Please extract the table. As per the table, according to the petitioner, according to the plaintiff, he had paid an amount of rupees 5 crore 34 lakhs 81,150. Even in the cross examination, it is stated that as stated in the plaint, he has made the payments. Now the present application is filed stating that in the above table at serial number 2, 3, 4 and 5, it is stated that he has paid an amount of rupees 65 lakhs, but it should have been 25 lakhs. And all these payments are by way of check. And even if that 65 lakhs is considered, the total amount would be coming to 6 crores 94 lakhs 84,000.
80,000.
80,000.
80,000. It will be.
6 crores 94 lakh 80,000. It is submitted that it is stated that it's a typographical mistake. As such, they may be permitted to amend the plaint. That came to be allowed by order imputed. Next paragraph. The trial court, while allowing the application, has observed that correction of a clerical or typographical mistake cannot be equated with withdrawal of admission unless it substantially alters the case. In the present case, the amendment appears explanatory in nature. Therefore, the court of the opinion that allowing the amendment would facilitate effective adjudication of the dispute and no irreparable prejudice would be caused to the defendant. Next paragraph. When counsel appearing for the petitioner submits that after the amendment to the CPC, Order 7, Order 6, Rule 17, the post-trial amendments cannot be allowed unless it is pleaded and unless it is averred and pleaded that in spite of due diligence that the said amendment could not be carried out at an earlier stage. It is further submitted that in fact in the suit in the cross-examination he has accepted the fact that as per the table in the plaint he has made the payments. Now by allowing
There's 65 lakhs I paid.
That's what, as per the table, that is.
No, not as per the table. The question was that 65 lakhs was paid. You have not paid 65 lakhs. He said false.
As shown in the table.
Lakhs.
That he has accepted that he has paid 65 lakhs as stated in the plaint. Now, by allowing this amendment, it amounts to taking away the admission made by the party, and that is not permissible, and court ought not to have allowed the amendment petition filed by the IA that's filed by the plaintiff seeking amendment of the plaint, and the order review needs to be set aside. Next para. When counsel appearing for the respondent plaintiff submits that it's a pure typographical mistake, and by amending the plaint, no prejudice is caused to the defendant, and in fact there is no change in the cause of action,
and even
nor in the nature of the suit.
Even in examination chief, I have correctly stated 25 lakhs.
And in the examination in chief, he has correctly stated the facts. It is submitted that the court has rightly considered and allowed the IA, and there are no reasons to interfere. Having heard Parusa material, having heard the counsels on either side, Parusa material on record. There is no dispute over the fact that in the plaint, the plaintiff has stated about certain payments and the mode of the payments. Some of the payments are by cash, some of the payments are by check. This 65,000, that is at serial number 2 to 5 of the table is made by way of a check. And in the end of that plane, the total amount has come to 5,34,000, 5 crore 34 lakhs 81,150. As rightly argued by the land counsel for the respondent, if this amount is considered as 65 lakhs at the column number 2 to 5, it would come to 6 crores 94 lakh 84,000. And moreover, these payments are made by way of check, and those checks are part of the record. In these circumstances, the trial court has rightly considered and rightly allowed the amendment, as it is a typographical mistake and it does not amount to taking away the admission. The courts will not let the parties uh, uh, a party to amend the pleadings, amend the pleadings where it amounts to change the nature of the suit or the admissions that are made by the parties. But at the same time, the amendment of pleading should be liberally allowed if they are necessary for determining the real controversy between the parties. In that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed.
13, Deepak Bhaskar.
Please, Your Leadership, I appeal to the petitioner. The dispute lies in a very narrow compass. The impugned order, Your Leadership, gets at
Petition is
page.
maintainable or not testable.
I'll address Your Leadership.
Section 299 of.
Okay. May I just point out what the issue is? My lord?
The morning I have.
I was here. This is a very peculiar dispute. I'll just explain why in 2 sentences. But in 2025, I issue a notice for partition to my nephew. What transpires from their response to the partition notice is that they had obtained probate of a will which is purportedly created in their favor by my mother. I am not a party to those probate proceedings at all. Your Leadership is aware the law is now settled that probate proceedings are proceedings in rem. So I ought to have been made a party. I'm not made a party in those probate proceedings. I then secure the papers of the probate proceedings. I move the court for revocation of the probate, because one of the conditions is if you're not made a party, you can seek revocation of a probate granted. The trial court proceeds to dismiss that probate application only on the ground of limitation. And the test applied for determination of that limitation is erroneous. It's an erroneous exercise of jurisdiction. What the trial court does.
No, that erroneous exercise of jurisdiction. Where is the remedy for the, generally, what is the remedy under 296 or 99?
299 is a residuary provision for all appeals under all orders of the district court. But you need, yes.
Why the district court cannot appreciate whatever the submissions you are making before this court?
No, because there is one additional factor. If Your Leadership will just have a memo of 6th April 2026. Unfortunately, this entire confusion appears to have arisen because of an error made by my counsel. If Your Leadership will just have 2 documents, please indulge me for 2 minutes. Please see page 39 of my petition. There is an extraordinary relief which only Your Leadership can grant. Please see page 39, paragraph 24. The petitioner only became fully aware of the fraudulent probate and transfer on 28/2/2025 when she received the reply notice dated 28/2/25 and upon independently verifying the scheduled property records. So this is what I've claimed as to the date of knowledge of the probate proceedings. Now please see the IA upon which orders have been passed. That Your Leadership gets at page 75.
So that's on the merits of the matter. We are
No, just it's on jurisdiction. On jurisdiction. If Your Leadership will just see this one page. At page 75. Sorry, 76. Now my counsel appears to have preferred an application saying that there is a delay of 3,818 days. That is from the date of the probate petition. Now Your Leadership will just see the memo that I have placed on record. I write to my counsel saying, look, the petition I have averred to the fact, I have sworn to the fact that I've only got knowledge of the probate order on 28/2/2025. So therefore, how can there be a delay of 3,818? I don't want to embarrass my colleague. The Leadership will just see the memo, what the reply is. This is not even an application signed by me. And the learned counsel who represents me says it's on the insistence of the court, Sharissa, that the application is filed. So therefore, my submission to your leadership is just that there is no delay on in filing the probate petition itself.
No, but ultimately the district court can also appreciate all this.
It's an extraordinary remedy. Ultimately,
If doesn't, then you can
convert it into.
Very well, your leadership may recall that.
The writ petition is filed. Questioning an order.
The page number 76 is not.
It's not done. Oh, sorry, 44.
Questioning an order dated 10th February 2026 passed by the so-and-so in I number 1 and the stainless number 506 of 2025. The learned counsel appearing for the respondent has raised the question of maintainability of this petition. As it is submitted that as per section 299 of the Succession Act, the remedy lies to the district court, but he cannot come before the court. Learned counsel of the petitioner submits that this is an extraordinary case where the appeal lies to the, where this court exercising the jurisdiction under 227 has to look into where the petitioner is not a party to the proceedings. And further, with the wrong advice, they filed an application for condonation of delay when it is not in the notice, when it is not required. This court has heard the counsel of the petitioner and also the objections that is raised with the learned counsel of the respondent. As rightly submitted by the counsel for the respondent, the petition before this court is not maintainable in the light of section 299 of the Succession Act. Then coming to the other submissions, all these aspects as well be appreciated by the district court where the petitioner has a remedy. And if the petitioner is dissatisfied with any order, he has a further remedy. In that view of the matter, this court is not inclined to entertain this petition. Accordingly, dismissed as not maintainable. The petitioner shall either be the liberty to the petitioner to avail the appropriate.
Would your leadership please also permit me to exclude limitation?
No, that I will not. That will be decided.
14, Sandesh Kumar.
Yes. ಇದೊಂದು ಅವರು ಜಸ್ಟ್ ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ ಅವರು ಪಾಪ ಲಾಸ್ಟ್ ಇಯರ್ನಲ್ಲಿ ಆ ಥರ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಫೈಲ್ ಆಗಿದೆಯಾ ಫೈಲ್ ಮಾಡಿಲ್ಲ
These petitions, the purchase is 10561. First one.
10561.
Now there are about, this is all about that, yes.
Sir, they are the purchaser of Bharat Stage 3 construction equipment vehicles. Those vehicles are manufactured before the cut-off date prescribed by the rules. Purchased before the, but
This is the one, yes.
the issue is, my lords, those,
What is the vehicle?
the first one, my lords,
Ajax Engineering
concrete
Private
mixer, my
Limited.
lords,
You purchased this vehicle when?
in the year 2021, my lords. 1 minute, I will tell. Page number, annexure C and D, my lords.
When they are manufactured?
Manufactured in the year 2021, my lords.
You purchased it in 21?
In the year 21. I have been permitted to register till 1/7/2023. Unless because the reason, many reasons, unless it has not been registered. Except that, unless all formats are completed because it has been manufactured before the cut-off date itself, purchased before the cut-off date itself. But the only thing is, it has not been registered. These issues are concerned, my lords, with respect to the many, there are more than 6 to 7 petitions are filed before Honorable High Court. The coordinate bench has been considered and permitted us to register the vehicles without quashing the notification. Under similar grounds, I came before the Honorable Court. I also be permitted to register the vehicle. If it is registered after the cut-off date, if it is manufactured after the cut-off.
When there is a circular, unless and until the court finds fault with that, how can there be a direction contrary to the circular?
My lords, because it has been, the only thing is, it has not been.
What I'm saying, if you question the circular and the court finds that that circular is bad, and they should do something contrary to that,
Objection.
So
That's the thing is, my lords, on the judgments which were passed by the coordinate bench, my lords,
Let's
has
see
not,
those
yes,
judgments.
has not been challenged as of now.
No,
When
it is-
permitted them to register, those tractors and construction equipments were registered.
Shall we look at that order? Where is that?
Yes, I have produced one order, I have produced, my lords, I will place. There are 5 judgments, my lords.
Copies could you? Copies.
Para 3, it is submitted.
My lords, my lords, I will take the judgment, my lords, passed in the petition number 1635 and connected matters.
1635.
1625 of 26.
1625. Next matter.
Judgment copy, now I haven't.
No, this is, no, who is the judge? You passed on so many.
Case Hemleka, Justice Hemleka.
Oh, yes. Hmm. Yes.
In the judgment, my lords, page number 16. One table has been extracted, my lords. My lords, in that table, my lords, BS4 has been permitted to register 1/7/2023.
No, coming to this stage, coming to this order, you have that order?
Yes.
Come to point number 2. Clause
Point
number 2 of
para
the,
number?
clause number 2 of the operative portion.
Operative portion. Yes.
The respondents are directed to permit the petitions to complete the process of.
Yes.
Do you find that? What will remain? The respondents were directed to permit the
In that
petitioner.
case, in that case,
So
yes.
generally I'm asking.
Yes.
Now, the court will permit them
Yes.
to register the vehicle.
Yes.
After that, it says, subject vehicles are subject to compliance with all statutory requirements. They cannot comply with the
True,
statutory
true.
requirements.
True.
That's the whole issue.
That's the whole. Moreover, my lord, if my learned friends cannot rely upon this judgment, please have a look at last paragraph
Yes.
in the page 20, Roman 4, last paragraph. It is made clear that this direction is issued having regard to the peculiar facts and circumstances and in the light of extensions granted up to April 26 and 6 month statute window, thereafter shall be treated as a one-time measure, shall not be cited as a precedent. Now, what would happen is, initially there was one case. The honorable judge, then there were a few more cases. Then honorable judge pointed out, as a one-time measure, shall we do it off, so that, why allow the, we also thought, no, my lord, after we did it, it's all trickling in. Even if your lordship passes an order today, there is no guarantee that more people will come. And they're all represented by the same learned counsel. At that point of time, when it was clearly made out by the honorable judge that as a one-time measure we are doing, the learned counsel did not point out that there are more number of people who may come. So this was done as a one-time measure, as a mercy petition.
Equality before law.
I'm sorry?
Equality before law.
Equality, but equality cannot be shown. We also kind of considered at that point of time. Otherwise, these are all stage 3 vehicles for which the time for registration has lapsed in 23.
No,
After that, we have got stage 4, stage 5.
This vehicle.
I'm sorry?
This vehicle manufactured in 2021.
Yes, 21. For 5 years, it has not been registered.
Why it is not registered?
And my lord, they will have to show, have they, let some RTO authority go and inspect the meter, trip meter, to find out whether they are operating or not. If they have been operating it without registration, it's a serious offense. So they have not made any disclosure in the writ petition. Can they file an affidavit and say, we have not, it's still in the showroom?
That's absolutely, there are, as per the information, still they have not used. But with respect to
this is a counsel submission. That let there be.
In respect,
No, the affidavit will be filed in that.
that I have to verify with the client, and then I will absolutely.
You can file an affidavit.
Absolutely.
Saying that there are so many matters listed in wherever you are not using, file an affidavit.
Yes, before that, initially the honorable, sorry.
So what I'm asking is, forget about what the earlier courts have said. Now, they have none of the orders are basing on any provision of law,
yes,
or in accordance with law.
Yes.
It's a one-time measure, one was some mercy shown on the.
Absolutely.
So now they are opposing it. I have to pass orders. I have to give reasons for it. So you argue the matter on the merits of it. Forget about the orders, earlier orders that are granted.
The initially, while disposing those applications, also the Learned Solicitor General has made a same submission. The thing is, the initial writ petition was filed by the dealer, the truck dealer. He has more than 56 tractors approximately. Those after permitted them to register, and that order has not been challenged. It is concluded. More of the central government has permitted to register those tractors registered. Afterwards, I am an individual. I am not a dealer. I am not a company. I am having a single vehicle purchased from the manufacturer dealer. I came before the Honorable Court. Only 4 vehicles till then, I have come to the Honorable Court. In these matters, I have only 7 vehicles. Moreover, those are all JCB operators. They are all having no worldly knowledge. They are just for the sake of livelihood. They have purchased the those equipments. The thing is, there are many reasons for non-registering the vehicle at the moment. Some petitioner will having a financial crisis because they have to pay the taxes more than 2.5 to 3 lakhs immediately. Sometimes, because of health issues, sometimes mechanical issues. There are 2 vehicles, some technical issues. It has been sent back to the dealer and come again. It has been delivered. All those things are there. That is why some days are dragged. Afterwards, the Act came into force. They have not come far because
when it has came into force.
2021 minutes.
That is the day when you purchase the vehicle, not later. As on the day when you purchase the vehicle, it is in force.
Yes, it was in force because some of the petitions purchased in the year 2015. Some 2 petitions are purchased in the year 2015. 2 petitions purchased in the year 2017.
Cost of the vehicle
Not
at that point of time is
registered till
31 lakh.
Vehicle which is purchased in 2015 is not registered till 2026.
Absolutely.
It has become a vehicle age about 10 years,
One must.
15 years.
If
There are certain again, there are different class of vehicles.
True.
If those vehicles are permitted to register, no hardship will be caused to the others. That is the only issue, because the party will.
Cost to them.
Because the persons who came before the dealer has been permitted, but private individual is concerned. The same principle has
Whole
to.
problem we shouldn't
That
have
is why.
been
That
done
is.
by them.
I am actually. The persons who have come before the Honorable Court, they are having a knowledge about all those things. The persons who came before now, compared to them, at any cost, more priority has to be given Honorable Court to these persons.
What the court can only do is they can adjourn the matters beyond August. Because I can't, I do not find any reason, so I will not dismiss it. And so you can take a chance with the similar orders. Because I am not convinced on the merits of it.
If I may, Madam.
Yes.
14.7, Madam. Means of peculiar circumstances. That's for the only reason. My lords may kindly produce my annexure A, Madam, in case number 15.
Number electrician, ನಿಮ್ದ 14.11 ಸರ್ ಅದು.
When did you purchase the vehicle?
1/4/2023.
14.7.
1/4/2023. We have paid the registration fees. And a vehicle number was also given to us. Subsequently, that was not continued by the RTO. We sought for registration. When we sought for registration, in page number 24, it was said that the portal is not permitting. For that reason, it cannot be registered.
Yes, have you seen this case?
That particular colleague, was traveling, is not available.
I think
You may, Lordship may have it next week, I'll get it.
This matter, I'll take it up next week. This is 14.7. This is matter next week. All other matters, they are.
In the meantime, that NIC, Learned Council may be directed to make that NIC also as a party, because they have to open the portal. So let them be also.
Okay, the petition is permitted to make NIC as a party. This is matter next week. This is matter on 24th June. Yes.
6324 of 2026.
14 point.
14.7.
2.
6324 of. This is manufactured in the year. 14.1. 14.1.
6324 is 14.1.
Yes.
ಅದಕ್ಕೆ ಯಾರು ನೋಡಿ ನಮ್ಮ ಮುಕುಂದ್ ಪ್ರಸಾದ್ ನಿಮ್ದ
In the month of June 2026. The time for extension, the vehicle should have been registered within 6 months from the date of the manufacture. But central government, by exercising powers, have been extending the time from time to time. Therefore, my lord, have also produced certain extension orders.
Yes, what do you say about this 24 vehicle?
Yes.
No, this is stage 3, my lord. It has lapsed. The time for registration has lapsed in 2023 itself. There is no extension.
It was manufactured in 24.
That vehicles are purchased by him in the year 2024, it seems.
Or 2024 also, which means 6 months from therein.
Yes.
There is no extension in their case. For these stage 3 vehicles, there is no extension. From the date of manufacture, they should have registered within 6 months.
The in all the matters which are returned, let the respondent file their objection.
We'll file objection.
Yes, let's just mark in the month of September, all these matters. Yes. Except 14.7. Yes.
15, Harish Bandari.
Lord, one submission. Lord, one submission. 14.7.
Serve the copy.
After the amendment. After the amendment.
After the amendment, make NS as a party. Yes.
For the petitioner in this case. Lord, in this case, my lord, earlier we have challenged the order of the trial court, my lord. But in the last date of hearing, my lord, the similar case has been already been pending consideration before the Dharwad bench, my lord.
Sorry, I'm sorry.
How can it be filed before Dharwad bench?
No, my lord.
No.
Is a
Oh,
case
that is with regard to the amendment.
amendment, Act 45 of 40 of 2020.
That amendment is filed.
Yes.
Against that, your lordship, 120 days lapsed with the.
Where is that amendment? Where is
I have
that?
produced, your lordship. Annexure. D.
IA number?
IA number, your lordship. IA number is your lordship.
Sought for amendment.
Annexure
Where is
C, annexure C, annexure C. Annexure C, along return statement along with the IA, that is annexure C, page 25.
IA number 1026 is amendment filed by you. That is what I'm asking.
Not amendment, your lordship.
Is it 50?
This amendment, your lordship, because now I have filed your amendment, because on the last occasion, your lordship has pointed out.
No, I remember.
Yes.
IA number.
Because since it is
1026 filed seeking amendment of prayer, as the petition is questioning the amendment to the CPC, that is Order 8, Rule 1. And this amendment is for
Act
40 of 2025.
2025, Karnataka amendment.
Amendment. The petitioner is questioning the same accordingly. The IA number 1 is ordered, allowed, and the petitioner shall make the necessary amendment to the prayer. Consequently, IA number 2 of 26 is also allowed.
Making me party, your
The
lordship.
petitioner to implead the state as a party to the to this writ petition. When counsel for the petitioner submits that in fact a coordinate bench of this court has I think this order is with Prabhu asking has passed an order wherein the court has directed all the trial courts, notwithstanding the said amendment, to consider the written statement that's all filed beyond 120 days. The judgment you asked him, in the light of the same, there shall be stay of all further proceedings. Notice to the respondents, petition is permitted to take out hands on. Is next.
Great, your lordship. Stay up, your lordship.
And summons and shall file a memo to that effect by 7th of July, or else the stay granted by this court stands vacated.
Deepa?
For the respondent.
I beg to appeal for the petitioner.
Last occasion, your lordship.
My lord, I would like to
Lordship,
submit
I make
all
a
memo.
Small submission. Last occasion, I made a submission that senior counsel is engaged. He's in adjacent quota. I have sought instructions. I'll continue, my lord. He'll come and join.
Yes.
My lord, a translated document.
The suit for?
Well, it's a suit for injunction under Order 39, Rule 1 and 2.
I have not served with the copies.
Well, the petitioner before my lordship is a village panchayat. Well, the claim of the respondent is that the land in question, which was all along be corrupt, by virtue of revenue records mutation, has transferred itself to a corrupt. Well, I will take my lordship to some of the provisions so that I can ventilate it a little better.
No,
Lord, can I take my lordship to?
No, before going to that, let me first understand what has happened to the, what is the finding. Then in
Both the trial court as well as the first appellate court was pleased to dismiss.
Let's see the order of the trial court. Where is it?
Well, I believe both the courts below have misunderstood the provision and the application.
First, let us understand what is that they have said. Then you can make your
page number 23.
Where is the order?
Page number 23 and 24.
Yes.
It starts from page 16, my lord. The operative portion, my lord, I would take my lordship's indulgence to page 23 at paragraph 15.
Come to paragraph number 15.
15. Yes, madam. Further, the plaintiff has also produced the copy of RTC for the year 1969 to 2002 in respect of serial number so and so, wherein there is a mention of 15 guntas of land as B Karab land. Further, the plaintiff has produced photographs and CDs on perusal of the RTC extracts till 2002. It is clear that there is 15 guntas of B Karab land in survey number 51 subclause 5. Further, the petitioner has also produced survey sketch certified by the Tahsildar, where it is notified that survey number so and so there is an encroachment, and also produced a letter of the Tahsildar and letter by so and so villagers, wherein it is mentioned that 15 guntas B Karab land in so and so survey number is encroached. On perusal of all these documents, it is evident that there is encroachment in survey number so and so in respect of Karab land. Further, the plaintiff has produced a copy of FIR and other relevant documents. On plain reading of the plaint, it appears in one breath the plaintiff has stated that the defendant is interfering in the suit schedule property, where, as in another breath produced documents, the petitioner is showing that there is an encroachment in respect of Karab land of 15 guntas. Such being the case, if plaintiff is not in possession of the said Karab land, claiming injunction by order of filing this application against the defendant is not maintainable. Well, this is in the teeth of the statutory provision and the dictum of this court in a number of cases.
What is the case for the panchayat?
My lord, the case of the panchayat is that 15 guntas, it is essentially a road along with a drainage ditch, which is used for public purposes from 1969. Now, what has happened is, my lord, in 2002, according to it is the case of the defendant, that the revenue record stood mutated, whereby from B Karab it was mentioned as A Karab. Thereby, they claim it is no more a public pathway. It shall essentially be at the usage of.
According to you,
Yes,
he has encroached the land, or you are in public or using the road?
Public or using the road.
It's not your case that he has encroached it and it's in possession now.
Well, now what he has done is he has put up some construction, he's put up some materials and things like that. Now, my lord, as far as the law with regard to conversion from B Karab to A Karab.
That will be decided eventually in the suit.
Yes, my lord.
For injunction, according to you,
yes,
what is the injunction you sought? What injunction you sought? Injunction restraining him from?
My lord, using the Karab land as a private land. Because it is a public land. This is why, my lord, the distinction between A Karab and B Karab is to be taken into consideration. Unfortunately, my lord, this is my case. Both the courts below has not considered this, has fell in error. My lord, the relevant provisions are very relevant for this. My lord, can I take my lordship to the compendium which I have given at page 1? My lord, for any.
Come to this paragraph number 18.
18.
Yes. In para 15 bottom.
Yes, my lord.
On plain reading of the plaint.
On plain reading of the plaint, it appears in one breath the plaintiff has stated that the defendant is interfering the suit schedule property, where, as in another breath, by producing documents, the plaintiff is showing there is an encroachment in respect of Karab land of 15 guntas. Such being the case, the plaintiff is not in possession of the Karab land, claiming injunction by filing this application is against the defendant is not maintainable. My lord, this is my entire grievance. I have all along produced materials to show that this is B Karab land. B Karab land, by necessary implication, vests with the government, with the public use. All the documents attest to the same. In order for you to convert it from B Karab to A Karab, there is a procedure contemplated under section.
When was it converted?
My lord,
2001.
2002, well, there is no order. In fact, the previous bench had quizzed them. Is there an order passed by the government under the relevant provision? Section 95 states you will have to make a necessary application before the commissioner.
No.
And
then where from they are saying that it is changed into A Karab?
Well, it is just a mutation entry. My lord, what has happened in 2002? 2002 there was digitalization. Now, in fact, if I took the today's mutation, today it is mutated as B. The revenue entries stands as B Karab and not as A Karab. In fact, my lord, it is well established. My lord, there is trite law that mere mutation of revenue records, it does not entitle you for conversion of land use. In fact, it has to be by virtue of an order passed by the competent authority in strict compliance with the statute. Now I would like to take my lordship to the statutory provisions, because why I insist is because, my lord, the courts below have not considered this. Assume for a moment that it has been converted to A-Karab. The revenue record stood mutated for whatever reason. Does it entitle or does it become that the B-Karab land has become A-Karab land? It is statutorily impermissible. It has to be by.
We are at the stage of interim injunction.
Yes, my lord.
We are not on the merits of the matter.
Yes, my lord.
So
No.
according to you, as in 2001,
Yes, my lord.
it was conversion, there was a conversion. So from, if their case is from 2001, they have been using it as their private land.
No.
Now, where is the question of injunction?
Well, that is not their case. My lord, that is not the case.
What is their case?
My lord, in fact, what has happened is, in pursuance to the revenue records being changed, which we feel that there is something more to be said about, be that may.
That in 2001, suit is of the year 2024.
Yes, it is only in the year 2025 they start putting up construction, start to encroach, preventing the villagers from using the pathway, which is from times memorial has been used as a pathway. To restrain them from preventing us from using it. It is at that point of time this was ventilated that the revenue record stood mutated in the year 2001, and hence it is no more B-Karab. The public cannot use it. It essentially stands as A-Karab. Now, my lord, even for balance of convenience, the prima facie case needs to be considered. My lord, it is in regard to an adjudication of prima facie case, I seek my lordship's interest.
As a prima facie case, what is the material you have shown before the court to say or to substantiate your case that that is being used as a road?
My lord,
there is an obstruction.
I would like to read again paragraph 15, my lord. These are the documents which were before them. Further, the plaintiff has produced a copy of RTC for the years 1969 to 2002 in respect of so and so survey number, wherein there is a mention of 15 guntas of land as B-Karab land. Further, the plaintiff has produced photographs and CDs. On perusal of the RTC extracts till 2002, it is clear that there is 15 guntas of B-Karab land in so and so. Further, the plaintiff has also produced survey sketch certified by the Tahsildar, where it is noticed that it is survey number so and so. There is an encroachment, and also produced the letter of Tahsildar and letter by so and so villagers, wherein a mention of 15 guntas B-Karab land in so and so is encroached. All these documents were produced to state that all along it was B-Karab. The consequence of B-Karab is, my lord, it cannot be used as a private property. Now, their only case and their only material is that in the year 2002, the revenue record stood mutated, or I would say stood changed, because mutation has to follow a process. If I take today's revenue records, it states it is B-Karab and not A-Karab. Now, my lord, for a mutation from B-Karab to A-Karab, a procedure is contemplated. A bare essential is an order by the competent authority has to be passed. Now, it has to follow the procedure contemplated under 95 and subsequently also under 97. Now, devoid of an order, devoid of a competent authority coming to a conclusion that what was B-Karab is no more a B-Karab and has to be, it is now an A-Karab, there needs to be an order. Now, all along, my lord, the learned courts have come to the conclusion that there are varied claims. There are RTCs after 2002 reflects A-Karab. In consequence to the same, we will decide it in the suit. My lord, that cannot be. In fact, my lord,
I understood your line. Let us hear.
In fact, I would rely upon two judgments of this court also.
That aspect.
This is a matter which requires imposition of exemplary costs. Now, whenever a PDO wants to file a case, it should be an assertion as to how the property is vested in the panchayat. Now, let us assume that the property is vested in the panchayat is the claim made by the PDO. Let's assume, lords. Under the scheme of the Panchayats Raj Act 1993, there is a provision which specifically provides as to how the claims in relation to the properties claimed by or against the panchayat has to be decided. Lord, section 210, can I just, Lords, may kindly see, because there appears to be something more than what the eye meets, Lords, in the manner in which it is being done. I'll demonstrate that there is a malice with which this litigation is being fought for. Probably the PDO is rendering his name because there are other elected representatives. I'll point out, Lords, with the materials I'll point out, there is a malice in this litigation. Lords, the properties and funds of panchayats is under chapter 15. Sorry, Lords, I just. Panchayat Raj Act.
They might not be having that.
Sorry.
Yes, you can read.
Lords, Chapter 15 speaks about properties and funds of panchayat. Gram panchayat may acquire, hold or dispose of the property. I will not trouble. Vesting of property in the gram panchayat. It shall be competent for the government, Jilla panchayat or Taluk panchayat with the concurrence of the concerned gram panchayat from time to time to direct any property vesting in the gram panchayat. So any plaint which is to be presented to say that a mandatory injunction, because there is no such, I am really startled in the manner in which the relief is, they say that you direct them to remove the obstructions which has been there. I'll even take your lordship to the cause of action. There should be a mentioning as to how the property belongs to the panchayat. It should have come in some manner. Now, even if it is a B Kharab land, let us assume, my lord, that's a B Kharab land. So far as B Kharab land is concerned, there is an entire scheme under the Karnataka Land Revenue Act, and the jurisdiction for the purpose of clearance of the B Kharab lands is only with the revenue authorities vested, my lords, under the scheme of the act. That is only the deputy commissioner, nobody else, under the scheme of the Karnataka Land Revenue Act, if their case is to be correct. But what he is arguing is not what the plaint says. The plaint says that I purchased the property in the year 2015. On the northern side of property, there is a road. He is encroaching upon that road. This road, according to the panchayat, is not part of this survey number, or it should be a survey number. It is part of the survey number as a B Kharab. He is encroaching upon that portion of the road which is being shown as a road in my sale deed. Therefore, there should be a prevention. This is the case which has been presented. Now, when it comes to the question as to whether the property belongs to the panchayat or not, section 211 says, in any village to which a survey of lands other than the lands ordinarily used for purpose of agricultural only has been or shall be extended under any law for the time being enforced, where any property or any right in or over any property is claimed by or on behalf of the Gram Panchayat or by any person against the Gram Panchayat, it shall be lawful for the assistant commissioner after inquiry of which due notice was given to pass an order deciding the claims. Any person aggrieved by the order of under subsection 1 has a right of appeal to the deputy commissioner. Civil court cannot consider these aspects at all, because when the panchayat comes before the court, they should realize that panchayat itself is vested with several powers. Now let us assume, my lords, that in respect of any road, there is an encroachment. Under the Panchayat Raj Act, there is a power that you are entitled to issue notice, hold an inquiry and clear the roads. There is no necessity for the civil court's intervention in the matter. Now, the reason why I said this is, there is already an existing road. Can I just pass on this because I have served these copies of the documents. There is already an existing road. Can I request your lords may kindly have a look at page number 1. Lordship gets it, lords. There is a road which enters from the main road, takes a curve and then goes. Now, this forms the northern side of the property where the construction is put up. This is the property which I have purchased. This road is even today intact. Next page. This is the road. What your lordship finds on the left hand side are the constructions. There is a road. And then I have produced as per the Dishang sketch. Of course, this may not be relevant for your lordship's consideration. Can I persuade that your lordship may kindly see page number 6, there exists a road. Not so far as this road is concerned, page number 8. Page number 8. This road is being, it's a properly formed road. And lordships may kindly see the bottom of the page in page number 8. The photograph is taken on 28/4/2026. It is a properly formed road. It is asphalted road. Whatever is existing as things stands. Nobody is encroaching upon that road. And this is the one which forms the northern portion of the road. Now, at page number 9, this is the survey sketch. Other than a Kaludari and a Nala, Kaludari, my lords, is a walking path. Nala, my lords, is where the water flows. Other than that, there is nothing else which is classified as a B Kharab. This is the original survey sketch. Lords, now, even assuming it's a B Kharab, their remedy would have been before the assistant commissioner, who would be an authority either under the Panchayat Raj Act to claim if it is a panchayat property, or if it is a part of a survey number but still a B Kharab, then it is the deputy commissioner who has to decide whether it's a part of B Kharab or not. Civil court cannot decide this question. Section 61 and section 63 of the Karnataka Land Revenue Act very specifically says there is a specific bar in relation to the issues that can be decided by the revenue authorities that could be decided by the civil courts. Now, factually, what the court found is, Lordships may have already gone through the orders, my lords, passed by the trial court. Can I just pursue your Lordships may kindly see the orders passed by the first appellate court. Para 18, my lords, in the trial court's order is the reasonings given, then the first appellate court's order. At page number 45, Lords, your Lordships may kindly take page 60, which is internal page 16, my lords, of the orders of the. This is something which, if your Lordships were to see, Lords, this secretary is purely an executive officer of the panchayat. There is an elected body. Elected body will have to take the decision what's to be done, what's not to be done. Para 22, my lords, of this order, your Lordships may kindly see. Lords, para 21 deals with the merits of the case. Para 22, the defendant's contention regarding maintainability of the suit based on the argument that Panchayat Development Officer failed to obtain prior permission or authorization from the Gram Panchayat or competent authorities before instituting the suit is an issue that necessitates thorough examination during the course of the suit during the full-fledged trial. Such a plea goes to the root of the plaintiff's locus standi and the procedural compliance required under the Panchayat Raj Act. However, at this preliminary stage, the court is not expected conclusively to decide on the maintainability of the suit, as the determination of this issue involves scrutiny of the evidence to establish whether the alleged non-compliance occurred, and if so, whether materially it affects the legitimacy of the proceedings. Question as to whether a proper resolution was passed by the Panchayat authorizing PDO to initiate the suit or whether permission is legally mandated under specific circumstances can only be ascertained through a detailed trial where documentary evidence such as minutes of the meeting, resolutions, communications with higher authorities are examined, witness if any are cross-examined. If only upon the conclusion of the trial, the court can decide whether the absence of prior authorization of proven vitiates the suit or other procedural lapses. If any, it can be cured or not fatal. Until the same, the court must proceed with caution, focusing on the substantive issues raised in the suit without preemptively dismissing it on the procedural grounds. Thus, the objection raised by the defendant regarding maintenance of the suit, while significant, must be reserved for final adjudication. Then, para 23. After a thorough review of the documents and the arguments presented, the court concludes that the plaintiff has failed to establish a prima facie case, demonstrate irreparable harm, show balance of convenience in their favor, thereby warranting the denial of temporary injunction sought against the defendant. While the plaintiff argued that the disputed 15 guntas of B Karab land in 51/5 has historically been used as a public road and submitted RTC extracts and survey sketches and a letter from the Tahsildar to substantiate the claim, these documents do not conclusively prove that the land was designated or consistently used as a public thoroughfare. In contrast, the defendant presented stronger and more reliable evidence, including the registered serial of 2015 recent RTC extracts from 23-24 encumbrance certificates, prior court orders, all of which establish his ownership and lawful possession of 30 guntas. Including the disputed portion, the RTC extracts specifically record the defendant's name as the possessor of the property,